Sir, we are live on Facebook and YouTube.
Okay. Good morning, good afternoon, good evening to all of you, wherever you are. Welcome to this conference entitled "The Road Ahead in Implementing Personal Data Protection
Sir, we are
Legislation
live on Facebook.
Effectively." Um, okay. Welcome. Good morning, good afternoon, good evening to all of you, wherever you are. Welcome to this conference entitled "The Road Ahead in Implementing Personal Data Protection
Sir, we are
Legislation
live on
Effectively." Um, okay. Shubham, welcome. Good morning, good afternoon, good evening to all of you, wherever you are. Welcome to this conference entitled "The Road Ahead in Implementing Personal Data Protection
Sir, we are
Legislation
live on
Effectively."
I think there is some
आपके ऐड से आ
problem.
रहा है सर
Uh,
आपने सर
Shubham,
यूट्यूब ओपन कर रखा होगा
Shubham,
शायद
welcome. Good morning, good afternoon, good evening
Shubham, can you please come
to
out
all of
of
you,
it? There's a
wherever
problem
you
in your
are.
thing.
Welcome to this conference entitled "The Road
इंदिरा
Ahead
सर आपके
in Implementing
लैपटॉप से आ
Personal
रहा है
Data
आवाज सर
Protection
Sir, we are live on
Effectively."
I think there is
आपके
some
ऐड से आ रहा है
problem.
सर
Indra, have you opened up the YouTube as well? That may be the reason then. You come out of YouTube.
Okay. I think the problem. Okay. All right. Okay, let me start once more. So, welcome all to this conference entitled "The Road Ahead in Implementing Personal Data Protection Legislation Effectively, Lessons from EU and Beyond." Myself, Professor Indranath Gupta, professor in the Jindal Global Law School, Dean of Research, and also the Jean Monnet Chair Academic Coordinator from 2020-2023 at OP Jindal Global University. This conference has been organized with the support of the Erasmus Plus program of the European Union and OP Jindal Global University. The Jean Monnet Chair, established with the support of the Erasmus Plus program of the European Union, provides an incredible opportunity to university professors specializing in European Union studies. It is a teaching position for the chair professor, and the professor should also engage in other additional academic activities. Under the Jean Monnet Chair, JGU would offer 5 different courses over the period of 3 years to all students and would organize a conference, a roundtable discussion, and a workshop, in addition to many research-related activities. JGU Jean Monnet Chair will contribute towards strengthening and deliberating the discourse on EU data protection framework through a specialized project with the overall objective of institutionalizing it within the multidisciplinary academic framework of JGU. With these words, let me welcome founding Vice Chancellor of OP Jindal Global University, Professor C. Rajkumar, to deliver the welcome address.
Thank you very much, Indra. First of all, I would like to extend a warm welcome to all of you to this fascinating conference on the theme, The Road Ahead in Implementing Personal Data Protection Legislation Effectively, Lessons from European Union and Beyond. I would like to at the outset extend our warm appreciation for the Erasmus Plus program of the European Union, which has supported this initiative. I would like to extend a warm welcome to His Excellency Mr. Hugo Astuto, Ambassador of the European Union to India and Bhutan, my dear colleague, Professor Dr. Mohan Kumar, and Professor Dr. Indranath Gupta. Extend my warm welcome and wishes to all others who have joined from the Nanyang Business School in Singapore, the University of Melbourne, the Shulani University in India, Maastricht University, also from Law Services, University of Utrecht, and IT for Change, Amarchand Mangaldas, Deloitte, Data Security Council of India, and many other organizations. It's actually a very important moment when we are having this conference because if there's one thing that the last 18 months or so since March 2020 has taught all of us is the role of technology that is going to dramatically inform, reimagine, and even transform all our societies. While we have quite dramatically embrace technology in all walks of life, including in education and healthcare. and other aspects as well. Some of the big challenges of of technology continues to remain writ large in our own initiatives. The issues surrounding privacy and data protection is something that will dominate our discourse, and law and policy is mostly playing the catching up game when it comes to the speed in which new technologies are constantly impacting our lives. So it is a conference of this kind which brings together people from different, disciplines, including law, but not just limited to law, to actually talk in terms of how all of us can be better prepared for dealing with this technology, and to what extent law and policy can shape itself better for preparing for the future. I'm grateful to the European Union for supporting us through the Erasmus Plus program. I do believe that there are a number of progressive developments that have happened in different parts of the world, led by European Union, and some of those best practices, including in legislation, in the role of institutions, to what extent judicial institutions and other such institutions can play in relation to evolving a progressive personal data protection legislation and policy. I also want to mention that this is something that uh, we need to take on board, the how we can influence the role of corporations and companies and business enterprises in this effort. I can't help but refer to the book of a very distinguished political and moral philosopher by name Michael Sandel, whose book entitled "What Money Can't Buy: The Moral Limits of Markets," where Michael Sandel argued. Michael is a very distinguished professor at the Harvard University's political philosophy department, and Michael has argued in that book, and that book was published maybe 5 years ago, and in which he talked about how increasingly our society is moved into a market dominated society where there are absolutely no limits. And the consequence of such a society, he warned, was two levels of consequences. One, institutionalized forms of inequalities, and second, institutionalized forms of corruption. And he talked about US, he talked about many parts of the world. I want to draw Michael Sandel in this effort in the beginning of the conference itself, is because of the fact that some of the questions that we ask in relation to data protection will have to challenge the existing paradigm when it comes to the role of corporations and companies. We cannot, accept that there should not be any limits on markets, and there has to be limitations on the role of markets and the role of companies when it comes to their own ability to use data. It's actually, in fact, Michael in his book makes a very important distinction between a market economy and a market society. He is in favor of a market economy where there is a fair amount of competition when it comes to goods and services, and and that's the role of companies to increase wealth and, of course, pay taxes and contribute to the overall development of a society. But a market society is something where everything that we do is measured in monetary terms, and such a society has disastrous consequences for the future. And the discourse and debate surrounding data protection legislation needs to challenge that status quo, need to recognize that there ought to be limits, and those limits may be moral in nature, and we need to impose on them, and through legal frameworks which will make those limits more effective when it comes to regulation, compliance, and accountability of all actors in this effort. I also want to mention that the role of academics is absolutely critical, because academic institutions are better positioned, somewhat of a neutral arbiters in creating thoughts and ideas that has the potential to navigate a very complex area such as data protection. There are numerous views and perspectives that are given from by different stakeholders and intellectually rigorous engagement that takes place in an academic setting, such as the conference that we're hosting today, will go a long way in providing more nuanced perspectives when it comes to data protection and beyond. Lastly, I want to say that the OP Jindal Global University has been spearheading this effort for the last many years now. We were founded in the year 2009, and just in end of this week, we'll be celebrating our 12th anniversary. And as we mark the 12th anniversary of OP Jindal Global University, I can only say that the key aspects of our learning has been to promote research, to create knowledge, to contribute to research and scholarship and publications, to develop an intellectually vibrant environment, to promote interdisciplinarity in our learning, and to collaborate with institutions in India and beyond, to work closely with the government agencies, to understand the functioning of corporations and companies, to partner with companies and other business enterprises, yet to maintain academic freedom and autonomy and independence, to advance some of these big ideas that are being discussed today. So, with those words, I want to once again extend my heartiest congratulations to the organizers, in particular, Professor Dr. Indranath Gupta, for putting together this conference, and his colleagues and team members to, in many ways, focus on an area that I believe is going to become even more important as we move towards greater degree of reliance upon data, greater degree on reliance upon technology, greater degree of dependence on non-state actors, including corporations, when it comes to data. With those words, thank you very much.
Thank you very much, Vice Chancellor. It was really, very thoughtful on your part to join this afternoon and sharing these wonderful remarks. Thank you so very much. Before I welcome His Excellency Mr. Yogo Astuto, Ambassador of the European Union to India and Bhutan, it's really a proud privilege to read out his short bio. Uh, Ugo Astuto entered the Italian diplomatic service in 1991. His career in the Italian Foreign Service spans experience in the embassies in Nairobi and London, including as alternate director for Italy in the EBRD, which is the European Bank for Reconstruction and Development, in the permanent representation in Brussels, and in the embassy in Delhi, where he served as deputy head of mission. From February 2013 until July 2016, he was seconded to the European External Action Services, which is EEAS in Brussels, first as a director for South and Southeast Asia, and then as deputy manager, managing director, director for Asia and the Pacific. From July 2016 to September 2019, he was a principal director for Asia in the Ministry of Foreign Affairs in Rome. He is the ambassador of the European Union to India and Bhutan since 2019. Welcome, sir. Thank you for joining us this afternoon. Over to you. Thank you.
Thank you. Thank you very much. Well, dear Vice Chancellor, Ambassador, Professor Gupta, ladies and gentlemen, it's a great pleasure for me to be here with you and to address this assembly, a gathering which is going to discuss pretty fundamental aspects of our societies, which are going to shape, in a way, the present and the future of our economies too. And I think it's clear the strong data protection rules are essential to guarantee the fundamental right to privacy. This is a central feature of any democratic society and an important component of an increasingly data-driven global economy. Identity theft, leaks of sensitive data, discrimination of individuals, inbuilt bias, intrusive surveillance tools. I mean, these are just a few examples of issues that we need to address and to address in the general public debate. The value of an efficient data protection regime has become even clearer during the coronavirus pandemic. The times we've been living through were marked by a step change in the use of digital tools. But new digital solution can only work in as much people are protected and people trust that the data will not be misused. Protecting personal data is also instrumental in preventing the manipulation of citizens' choices. In particular via the targeting of voters based on the unlawful processing of personal data. So what I will try to do is to share here with you the perspective deriving from the experience that the EU has gained with its General Data Protection Regulation, GDPR, since 2018, and the relevance of GDPR and in the international context, both globally and possibly here in India. So let's start by recalling why GDPR has become a sort of a landmark. Well, it has been adopted recently in 2018, but yet it has developed quite a surprising fame internationally, surprising for a legal act. EU citizens, for instance, are massively aware of the regulation. But based on a recent survey, 69% of EU citizens know about GDPR. Civil rights associations and consumer organizations consider GDPR an important contribution for a fair digital society built on trust, on mutual trust. And the UN Secretary General Guterres recently noted how the GDPR has set an example, inspiring similar measures elsewhere. So what has the GDPR done? Well, it has introduced a modern data protection regime based on 4 pillars. First of all, by setting an horizontal overarching law rather than sectorial rules. Secondly, by setting a core number of data protection principles. Thirdly, by empowering individuals with the right to control their data. And finally, with the creation of an independent supervisory authority with effective powers to enforce these rules. So the GDPR has provided individuals with innovative and enforceable rights, such as the right of access, of rectification, erasure, the right to object, and the right to portability. And it is also given in enhanced transparency. So far, it has proved to be a flexible and effective tool. And this has been further demonstrated during the COVID-19 outbreak. And in a way, it facilitated the uptake, the adoption of tracing apps by users, since people were confident that the personal data would be protected under the umbrella of GDPR. GDPR has also gained traction because it proved that personal data protection does not necessarily hinder innovation. On the contrary, GDPR provided legal certainty, be it for individuals or for business, in a landscape which was previously somewhat fragmented among the 27 EU member states. And we hope it has also set a model for international data transfers. So this is a framework set by GDPR. What were and what are the challenges for the implementation? I will start by stating that individuals are increasingly aware of their rights. Right of access, right of rectification, right of erasure, the portability of their personal data, the right to object to a processing. And people are also aware of the need for enhanced transparency. In the EU, individuals are actually using these rights. However, many still do not take active steps to protect their personal data when they go online. So therefore, there is a need to facilitate the exercise of these rights and the full enforcement by individuals. And this by giving to individuals all required information. But this information is to be given in clear and plain language. Otherwise, if it's not understood, it's not valid, and these rights remain on paper. Individuals facing a binary choice may not be able to fully assess the risks involved. That is why the GDPR does not condition data transfer solely to individual consent, but also includes further safeguards. And this is particularly important for international transfers, where standards abroad can be significantly different and sometimes lower. So user consent cannot be the only solution. Calls have been made in Europe to give individuals the tools to manage more effectively their data at a granular level. And several initiatives have been presented proposing tools for consent management, personal information management, and personal data spaces. Well, in India, the data empowerment and protection architecture supported by NITI Aayog is proposing a practical solution to turn data subjects into active agents managing their own data with the support of neutral data intermediaries. The EU Data Governance Act is suggesting similar solutions. And this is a promising field for international cooperation and to develop global effective solutions. The EU Data Governance Act was published in November 2020. It proposes a legal regime for developing neutral data intermediaries. This has the potential to bring a major shift in the data economy, where much too often we see services provided in exchange for the sharing of personal information. So these were a few of the challenges for implementation. Let me come here to another key aspect of this topic, which is enforcement. Effective application of these rights and these rules need proper enforcement. National Independent Data Protection Authority in charge of supervising and enforcing the application of data protection law are a cornerstone of the GDPR and of its success. While these independent data protection authorities have not shied away from using their enforcement power when necessary, they have focused rather on dialogue rather than sanctions, in particular for the smallest operators. Operators who do not process personal data as their core business, as their core activity. In our view, the success of the regulation should not be measured by the number of fines imposed, but by the changes in the culture, the changes in the behavior of all actors involved. Our experience has also shown that adequate resources and a consistent approach represent critical elements for the proper functioning of data protection authorities. Data protection authorities can pool their efforts on issues affecting more than one member state in Europe. And the European Data Protection Board fosters the harmonization of the interpretations throughout the European Union. And we feel that this coordinated approach among the 27 can also be a source of inspiration for international cooperation. Now, let me touch on GDPR and the new technologies currently developing. New technologies offer unparalleled opportunities for innovative business models, for social knowledge, for better governance. But they should not lead to the extremes of what has been called surveillance capitalism or surveillance state. In this sense, the EU data protection legislative framework is a cornerstone of the European human-centric approach to innovation. It is becoming part of the regulatory floor for a widening range of policies, including health or research, but also artificial intelligence, transport, energy, competition, and law enforcement. Let me make an example here. The draft artificial intelligence regulation, which has just been published in the European Union in April 2021. But this regulation confirms that artificial intelligence application must comply with the fundamental rights. Individual interests and the social goods are to be preserved. And despite the fact that GDPR does not explicitly mention artificial intelligence, many of its provisions are relevant to it. For instance, those referring to automated decision making. Many artificial intelligence applications involve the massive processing of personal data, including the targeting and personalized treatment of individuals on the basis of such data. Now, data protection principles such as purpose limitation, data minimization, and data subjects' rights, such as the rights to access, to erasure, to portability, and the right to object. But these are aspects that are also very relevant within the coming regulatory framework for artificial intelligence. With the use of connected objects at home, what we call the Internet of Things, consumers will generate even more data. And the ownership, as well as the decision level and mechanism to share this data, should be scrutinized, considering both the protection of privacy and the benefits to the economy and society. The European data strategy presented in 2020 announced the intention to explore how best to enable the use of data held in public databases for scientific research, but in a manner compliant with GDPR. It wants to make it easier for individuals to allow the use of their data for the public good. For instance, to foster research in the health sector, but only if they wish to do so, based on the principle called of data altruism. Let me pass now to some reflection concerning the international dimension, starting with adequacy. From Chile to South Korea, Brazil, Japan, Kenya, and India, many countries around the world have adopted or are about to adopt comprehensive data protection rules based on principles similar to those of the GDPR. And this should hopefully result in a global convergence of data protection rules, at least among like-minded countries. So this offers the opportunity to create a network of countries where data can flow freely and safely between commercial operators or public authorities. The European Union has already recognized many countries as providing adequate protection. Just a few examples: Japan, Argentina, Israel, New Zealand, Uruguay, and the list is expanding. As procedure for adopting adequacy decision for South Korea has already been launched in June 2021. Now, India has not yet adopted its own legal framework, and obviously we cannot predict at this stage the actual perspective of striking a similar deal. But ideally, we hope that we can aim at the free flow of data in both directions. An adequacy agreement could complement well also the future free trade agreement between the European Union and India. As you all know, the decision has just been taken to resume talks on the free trade agreement and on investment agreement. The EU and India share a common vision, which was restated again at the last EU-India leaders meeting in May. Let me quote here what the leaders say. We agreed to continue enhancing convergences between our regulatory frameworks and to ensure a high level of protection of personal data and privacy, including through possible data adequacy decisions with a view to facilitating safe and secure cross-border data flows between us. Now, the EU and India are two large regions and two large economies sharing the values of democracy, sharing fundamental the belief in fundamental rights and the rule of law. And we can definitely offer a positive contribution to the shaping of global standards, also when it comes to data protection. Again, touching on the international dimension of data protection, let me mention the principle of data free flow with trust, which has been adopted at the G20. In August 2021, the G20 digital ministers declared that in a world that is often fragmented, increasing convergence offers new opportunities to foster future interoperability and to harness the digital economy, provided we can together protect the data of our citizens. The Data Free Flow with Trust initiative was endorsed by G20 and G7 leaders in 2019. Let me underscore, it is not equal to an unconditional commitment to free data flows, but the initiative is about making sure that data can flow if there is trust. And for the European Union, trust means inter alia data protection. This is an issue where India and the EU have a lot in common. We are exposed to similar threats from authoritarian regimes that do not ensure minimum safeguards against disproportionate government access to personal data, for instance. So this is an example of missing trust that justifies restriction then to data flows to and from these countries. But the EU and India, as like-minded democracies with sharing values, well, we then need to work together on common responses and common safeguards in order to ensure that the flow of data is based on a high level of protection, including protection from disproportionate government access. Now, there is no one-size-fits-all solution for data flows, obviously. And the European Union is also working to harness the full potential of the regulations toolkit for international transfers, including to countries with different and lower standards. Instruments such as standard contractual clauses, the development of certification schemes, codes of conduct, administrative arrangements for public bodies, well, these are all part of the toolkit for international transfer, where you don't have a data adequacy agreement. The standard contractual clauses in particular allow data transfers between business under the EU data protection regime. The European Commission has just updated these clauses in June 2021. They represent a pre-approved, user-friendly and reliable solution, including for international transfer to countries with lower levels of protection. And the recent OECD study demonstrated that this tool is increasingly used by companies around the globe. So their broad use indicates that they can be helpful to business and of benefit to companies that do not have the resources to negotiate individual contracts with each other on their data processing contractors. So let me come to a conclusion here. And I think the main conclusion I would draw is that the GDPR has successfully met its objective in terms of strengthening the protection of individual rights to personal data protection. And in guaranteeing the free flow of personal data within the European Union. In an economy increasingly based on the processing of data, GDPR has proved an essential tool to develop trust, to develop the trust of users and to give individuals better control of their individual data, and ensuring that this data are always processed only for a legitimate purpose, in a lawful, fair and transparent way and in compliance with fundamental rights. Now, more can be built on those foundations. Obviously, we adapt the legal framework to new technologies, allow better data governance for shared social and economic objectives, better empower individuals. That's the discussion, the conversation is open on that, obviously. India is currently reflecting on its own data protection framework and adopting a modern data protection law in line with its own democratic values will not only benefit India's digital and service industry, but it will also bring significant traction to the region and worldwide as a model. And with this in mind, in the EU, we see these as a potential milestone. So let me close indeed by wishing you a very enriching conference on this topic, a topic which is essential for our society. And I look forward to hearing your contribution to the public debate, contributions for the benefit of India and the global community. Thank you very much.
Thank you very much, His Excellency, Mr. Hugo Astuto. It was really a comprehensive discussion talk, sir, and we hope to discuss some of the issues that you have mentioned in the conference. Also, as you have mentioned that trust is at the center of everything, and we want to build that trust while data is flowing from one place to another. With that, let me also welcome now Professor Dr. Mohan Kumar, Dean, International Affairs and Global Initiatives, Professor of Diplomatic Practice, OP Jindal Global University, former Indian Ambassador to France and Bahrain. He has been in the Indian Foreign Service for more than 36 years, and he's an excellent speaker and an academic. So welcome, Professor Mohan Kumar, for your special interest. Thank you.
Thank you, Professor Indranath Gupta, founding Vice Chancellor of the OP Jindal Global University, my good friend, Ambassador Astuto, Ambassador of the European Union to Delhi. Ladies and gentlemen, I think comprehensive speeches and interventions have been made. I would therefore like to approach this particular opportunity that you've given me to make use of it by saying that there are a few issues that the conference could focus on, which could be extremely useful from an Indian perspective. I see some very learned colleagues from Europe, and I think the conference should exploit their presence. I first want to start by saying the conference is timely. I want to congratulate Professor Gupta and your colleagues for organizing it. They say data is the new oil. And if that is true, then there are two continents which have unlimited riches at their disposal. One is India, the other is Africa. Every other continent has already mined its oil and used it. China doesn't give its oil to anybody. It's only Tencent and Alibaba and so on. Europe and America, the data is already mined. So unmined virgin data is available only in India because so many people haven't yet accessed the internet, and of course, Africa. I would posit that the African data market is fragmented. So frankly, for India, data holds a lot of promise, but it also holds a lot of challenges. In terms of data, if I can break it down, essentially, the thing about digital trade and data is who owns data, who monetizes data, and have you asked the consent from the owner? Really, it is as simple as this. How to sort out these three things. This is what countries all over the world are struggling. And you've got personal data, you've got anonymized data. Anonymized data is the number of cars, for example, which pass at a green light or a red light. That is anonymous. Whereas if you're talking about the number of people who have diabetes and whether the person's health record, that is personal data. So this is basically the universe of this data privacy. And the Personal Data Protection Bill of 2019, as was hinted by the EU ambassador to India, is largely based on GDPR. So that's the good news. It's broadly based on GDPR, so it meets international standard. The trouble is, whereas European Union has got directives to check the power of the Data Protection Authority or the government, in India's case, it is the feeling of a lot of people that it gives government too much power. So coming to the Indian example, the Indian Constitution does not provide right to privacy. anywhere. It's not listed. The Supreme Court in a case, Puttuswamy versus Union of India, and I think that's a case well worth reading for all your law, people who are interested in the subject, that essentially spelled out that the privacy right is a fundamental right, and it included it under Article 21 of the Constitution. So we don't have anything in the Constitution, but we have judicial interpretation of the Constitution, which includes the right to privacy. There are some tests which have been laid down by the Supreme Court, which is that there must be a law before. The real question for India, and this is where we can take help from our European Union professors, is the right to privacy applicable to also the government or not? That's the bottom line. Because a good data protection bill must also be applicable to the government, not just to the individual, which means you have to provide for excessive action by the state and how you can guard against it. That really is the bottom line for India. And the test which has been outlined by the Supreme Court is that there must be a law, first of all, so there must be a legal framework. It can't be an executive decree. Second, whether there is a legitimate state interest involved. And third, the test of proportionality. Now, if you talk of the test of proportionality, it basically says state interference must have a legitimate goal. It must constitute a suitable means of achieving the goal. And there must not be any less restrictive but equally effective alternative to achieving that goal. I think according to activists, the Personal Data Protection Bill, while largely based on the GDPR, as I said, it does give a lot of discretionary power to the government. And this is what we need to look at. For example, data is classified into three categories. You've got personal data, you've got sensitive data, you've got critical data, according to the Personal Data Protection Bill of 2019. Personal data, there is no restriction. It can be, if it is not sensitive, if it is not critical, can be transferred and stored anywhere. That's not a problem. But if personal data is sensitive, then it can be transferred out of India, but it must be stored in India. Now, this is where we need some understanding from our European colleagues. The EU ambassador very rightly pointed to data flow with trust. The Indian challenge is essentially about data localization, because we want sensitive data. We have no problem. And when I say sensitive data, we are talking about an individual's information with regard to health, religion, sex habits, biometric, political beliefs, caste. All this is sensitive. Now, this can be transferred out of India in some circumstances, but we don't want information on this to be permanently stored outside the country. We want it to be stored within the country. Now, this is an area where we may have a slight difference of agreement with our European friends. When they talk of data flow with trust, they are talking obviously in terms of unimpeded data flow. Now, when it comes to critical data, we obviously believe not only can it not be transferred out of India, it should also be stored in servers in India. This is really the bone of contention between EU, United States, and India. We are obviously much closer to the EU than with the United States. The US generally believes the government should have no role in all this. There should generally be a free flow of data. So I would say that we have to sit with our European, but this conference can do one thing. There are some EU directives which have created checks and balances for the Data Promotion Authority of the United States. As you know, the Personal Data Protection Bill of 2019 creates a data protection authority exactly along the lines of the EU. There's no difference. The only difference is EU has got directives which put checks and balances on these exemptions. Even the exemptions, by the way, are there in the EU law. It's not that it is not there, but the EU has created checks and balances. I think one of the things that this conference can do is to seek those EU directives from the learned professors from EU And if we can create something along those lines to create checks and balances on the government. For example, one of the criticism made against the Personal Data Protection Bill is the government of India has more power than the Data Protection Authority. Now, that doesn't make any sense at all. The government cannot say, for example, that none of these things apply to its agencies. The declaration of national security interest is too broad. It'll have to be narrowed down further. So we have some of these things that we still need to do. And some blanket exemptions have also been, for example, the criticism of the PDP bill is that the power given to GOI in terms of exempting its own agencies is very, very broad. National security exemption must be based on law, not on an executive order. And the PDP expands the scope of exemptions effectively. And this is a bit of a problem for India if it has to gain acceptance of this concept of data flow with trust with EU. I do believe actually that if we can sit together with EU, I mean, India's strategy in terms of e-commerce negotiations, digital trade, must be to reduce the disagreement with EU, because then EU and India can form an effective negotiating strategy vis-a-vis United States, because there is an understanding even in the United States that an unregulated market is not a good idea. We all know what happened with Facebook and Cambridge Analytica. And even Mark Zuckerberg was forced to admit in front of the American Senate that some regulation must be there. The question really is, are we going to have regulation light, LITE, which is what the United States wants, or are you going to have hardcore regulation, which India? EU, I would say, is somewhere in the middle. And in this particular context, I dare say the EU has got it right. It's a golden median they've got between the American model of no exemptions and between the Indian model of blanket exemptions. I believe the EU may have got it right. And I think this conference can benefit enormously if we can understand the EU directives, not the EU law, because that is published, that is well known, the GDPR. I'm talking of the various EU directives or directives which actually provide checks and balances to the Data Protection Authority of the EU. I think that if we can get a complete list of what those directives are, then I think we will be able to kind of tell the Indian government, make petitions saying that, listen, we should get it right. I am, by the way, extremely concerned that 23 sittings of the Joint Parliamentary Committee have happened in India with absolutely no success at all. You know, if data is the new oil and you are sitting on huge amounts of oil, you are leaving it completely unregulated for the time being. For the time being, India is in a precarious situation where the constitution does not provide right to privacy. There is no data protection bill, so there is no regulatory framework. It's a law of the jungle right now. And how long are we going to keep this situation or allow this situation to continue? So actually, it is in India's interest to bring this PDP bill to fruition. And that must be done sooner rather than later, because postponement doesn't solve anything. As the founding Vice Chancellor rightly said, technology is leaping ahead and regulation is having to keep pace with it. So the more you wait, I would argue the more difficult it will be for India to get it right. So I'm going to stop here, Professor Gupta, because I don't have too much to add. There are people who have made comprehensive interventions, but I do believe the conference can serve a very practical value if we can try to understand, in addition to the Data Protection Authority of the EU, what are those executive decrees and directives which have been issued by the EU, which can then serve as a model for India to follow when it actually finishes its examination of the Personal Data Protection Bill. And hopefully we will get that bill passed in Parliament before the end of the year. So once again, thank you very much for the opportunity, and I join the others in wishing the conference all success.
Thank you, Professor Kumar, for those wonderful, words and insights, sharing those insights with us. Actually, I'll take this opportunity to also tell you and His Excellency the Ambassador and the Vice Chancellor that the conference is divided into three parts. It is the first session, the technical session, which is going to start in about 10 minutes' time. It will looking at data privacy framework at the conceptual level, and then we break it down further, as the ambassador was talking about, the granular level, looking at the role and relevance of GDPR, and then end the conference. The final session would be meeting challenges in implementing data privacy, as the ambassador was saying about when advancement of technology, and as the vice chancellor and yourself, you're talking about these important issues. I think these are crucial times, of course, for India as well as for the world. And there is a lot of reliance on EU GDPR to set the foundation to any form of data protection in a sovereign country. But we have to wait and watch as to what would be the final shape given to the protection in India that the bill has envisaged, and what has been envisaged by the committee, which was headed by Justice B.N. Sri Krishna, former judge, Supreme Court of India, and the team. And we have to wait and watch as to how the EU GDPR probably will be positively influencing other jurisdictions to come up with a robust framework. It marking, the ambassador noting the point the ambassador just raised. It's extremely important to have some sort of arrangement between nations to ensure there is smooth flow of data from one nation to another nation. And therefore, we are looking at a lot of similarities instead of having a lot of sharp ends. So on that note, let me thank you, all our speakers in the inaugural session, starting with His Excellency Mr. Hugo Astuto, Ambassador of the European Union to India and Bhutan, for delivering the wonderful inaugural address. Our dear Vice Chancellor, Professor C. Raj Kumar, founding Vice Chancellor of Operationalization Global University, delivering the welcome address. Professor Dr. Mohan Kumar, Dean International Affairs and Global Initiatives, Professor of Diplomatic Practice, and former Ambassador to France and Bahrain, for delivering the special address. We thank you all for joining us this afternoon on a Monday afternoon, taking time out of your busy schedules. And thank you, and we look forward to meeting and interacting with you on all these issues. Thank you, and have a wonderful day ahead. Thank you very much.
extending a very warm welcome to our esteemed speakers today, respected faculty members, our dear students, and all the guests present for this session. My name is Krishnadev Singh, and it is my pleasure today to moderate this session where we will be focusing on the fundamentals of understanding data privacy framework. It would be appropriate to say that the relevance of data privacy frameworks has grown exponentially over the past few decades. While the European Union brought its updated privacy regulation in force in 2018, we are witnessing several other jurisdictions at various stages of conceptualizing or enforcing their own versions of data privacy laws. These laws are expected to be one of the most significant catalysts of change in all spheres of the human community in the times to come. But data privacy laws, in their very ontology, are uniquely positioned. On the one hand, they borrow substantially from the foundational jurisprudence of modern legal systems, relying on concepts such as individual dignity, autonomy, and fairness. On the other hand, they are impacted by the changing dynamics of the technological paradigms and the latter's impact upon the value systems within our societies. In the landmark Indian case of Justice Puttaswamy versus Union of India, the much cited case, Justice Chandrachud stressed that data privacy is an integral part of the larger fundamental right to privacy. But at the same time, he also noticed that, quote, in an age of rapidly evolving technology, it is impossible for a judge to conceive of all the possible uses of information or its consequences, end quote. It is in this light that we will proceed with today's session on understanding data privacy framework. We will focus on delving into the foundations of several vital concepts in the data privacy frameworks, the discussions which will be led by our distinguished and learned guests. Before I proceed with inviting our first distinguished speaker for the day, I would like to request the participants to kindly put their questions on the chat box accompanying the stream, and we will take these questions up towards the end of the session. Now, with that, our first distinguished speaker for the day is Professor Dr. Mark Taylor, Associate Professor in Health Law and Regulation at Melbourne Law School and Deputy Director of the research group HELEX, which focuses on the legal and regulatory frameworks governing new health technologies. His own research is focused on the regulation of personal information with emphasis on health and genetic data. Today, Professor Taylor will focus on fair and reasonable processing of data, a concept that lies at the core of modern data protection systems. With that, I request Professor Dr. Taylor to please address the gathering.
Thank you very much. It's an absolute delight to be here. Thank you very much for the invitation, and I'm very much looking forward to taking part in today's discussions. Let me just start by sharing my screen. Okay, hopefully you can now see my screen.
Yes.
It's usual. I'm speaking to you today from Australia, and it's usual to start any public presentation with a recognition of the traditional custodians of the land. And so I'd just like to start by acknowledging that I work and I live on the lands of the Wurundjeri people of the Kulin Nations. I recognise them to be the traditional custodians of the land, and I pay my respects to their elders, past, present, and emerging. It's a beautiful country. I'm looking out now at a reserve, and you may be able to hear at some point the cockatoos that we're coming to roost in the tree behind the house. So I apologise for any screeching, but there's not much I can do. They come in at this time of the evening. So I've been asked to speak about the subject, the concept of fair and reasonable processing. So what I want to do is to start very conceptually, just saying what might this require, what might the concept of fair and reasonable processing look like? And then just to say a little bit about where we are in Australia right now, and say a little bit about privacy and data protection law and its regulation of fair processing. We're in a point of some reform So we'll be looking at some of the questions which Australian regulators are now grappling with when it comes to strengthening the fair processing requirements. And then as we look at some of those questions, hopefully that will help fuel the discussion which will follow when it comes to understanding what are the relative benefits and disbenefits of pursuing different interpretations of fair and reasonable processing. Okay, so I'll start by just saying something about what the term could mean. Apologies for those of you who've seen this dial before. I have used it before in a presentation. It's outlining a spectrum of possibility that I am myself seeking to better understand and consider right now. So it's a spectrum of possibility that advances different ideas of fair and what fair might mean. And it starts with the dial set quite low, kind of the first setting on the dial, would require any fair processing to be transparent and honest. That's pretty significant in itself, but what constitutes fair and reasonable is really shaped by what you tell people you're going to do. It's shaped by notice, and it's shaped by the context within which any data is collected. What you're doing is you're enabling individuals to protect their own interests. You're giving them fair warning that this is what we're going to do. So really, it's about empowering individuals to make choices for themselves. We'll tell you this is what we're going to do with the data. You then decide, on the basis of the information we have provided, whether or not you want to engage with us. But as long as all that we do with the data is what we have told you we will do, that's fair. Now, as we'll discuss in this session, I'm sure, there are some limits when it comes to the extent to which such a conception of fairness can protect individuals at a time when people tend not to read all of the information in privacy notices, don't read all the terms and conditions of the services we sign up to, and aren't necessarily in a position where they feel able to decline the terms and conditions or to negotiate them if they want the service, and sometimes they might. Zoom and other kinds of video conferencing facilities. How many grandparents feel able to decline the terms and conditions when they sign up to these video conferencing services if it's the only way they get to speak to their grandchildren? But this is kind of the first setting on the dial. Transparency, honesty. You tell people what you're going to do, you're held accountable if you don't do what you said you would, or you do more than you said you would. The second setting on the dial is a slightly thicker conception of fair. It requires more than mere transparency. It requires more than you to do what you said you would do. It also requires that any interference with an individual's interests, any interference with an individual's privacy, is no more than is both necessary and proportionate in the circumstances given the interests that are being pursued by the data controller. So here, an interference with privacy may be permitted, but only insofar as it can be justified. So there is to be no unjustified harm. So this goes beyond transparency and honesty because there is a limit. You can't just rely upon individuals exclusively to protect their own interests. People will also be protected against any adverse effects that cannot be justified in the circumstances. The processing is subject to this test of necessity and proportionality, and there can be an objective assessment by a regulator if necessary as to whether or not there is a fair balance between interests in relation to processing. So a slightly thicker conception of fair than we saw in the first setting on the dial. But there's another way you can understand fair, and it goes even further than that. You can understand fair to be not only transparent, but also trustworthy. Now, we've mentioned trust a couple of times today. I've heard it mentioned by a couple of speakers. We only want to cultivate trust in organizations that are worthy of it. The literature on trustworthiness often notes not only the competence of organizations that are trustworthy, but also their motivations. One of the things which is critical to trustworthiness is the idea that people aren't going to take advantage of the power which they're given, not taking advantage of any power imbalance. They're going to act in the interests of the individuals who have entrusted their data to them. Trustworthiness is associated with this notion of beneficence. So here's another way of understanding what fair and reasonable requires. In order to be fair, you don't just have to be honest. You don't just have to interfere with an individual's interests no more than is necessary and proportionate. You actually have to positively seek to act in the interests of others. Sorry, that wasn't the cockatoos, that was a dog that's now chasing the cockatoos. Fair and reasonable is shaped by notice and context, but ideas of loyalty and beneficence. And I know that Jeannie will be speaking later about the notion of data fiduciary, so I'm not going to say more about that. But here, again, adverse effects are objectively assessed. And here they're objectively assessed not only for their necessity and proportionality, but they're assessed for their consistency with duties of care and the best interest test of the data subjects. So increasingly demanding requirements of what fair means, increasingly demanding, we're getting a thicker and thicker concept of what fair means. And any regulatory system which seeks to introduce a fairness requirement into data processing will have to determine where it is going to set the dial. Transparency will be the minimum. Transparency and honesty, making sure people only do what they said they would do. But it is possible to understand fair to require more than that. So where are we in Australia right now with regards to where does Australia set the dial? And I'm going to very quickly just outline a couple of pieces of law which contribute towards an answer to that question. The first is Australian consumer law. Section 18 of the Australian Consumer Law says, a person must not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive. So any organisation that is acting as a data fiduciary, as a data controller, that is seeking data from a data principal or data subject, must not act in a way that is misleading or deceptive or is likely to mislead or deceive, insofar as that a conduct is associated with trade or commerce. So any commercial acting has to be consistent with this requirement of the Australian Consumer Law. Now, the Australian Competition and Consumer Commission, the ACCC, is the regulator that is responsible for taking action in cases where there's questions as to whether or not Section 18 has been breached. And it has recently taken action over the last couple of years in a couple of notable cases where what has really been protected is individuals' privacy interests. So there was a case in relation to a company called Health Engine that was collecting data through an app that was used to book appointments at a GP practice, and the data that was collected through the app was then distributed to third parties who then followed up for the purposes of marketing, insurance, or offering legal services. And the ACCC said the information that was being provided to consumers in that circumstances didn't lead them to believe that this was something that would be done with their data. Consumers in this context were misled as to what would be done with their data. And in ACCC against Google, again, there was a question as to whether or not consumers were misled with regards to their location data and whether or not it was going to be collected when certain settings on the phone were off. So we have here consumer law coming in and saying, look, you can't do things that are misleading or deceptive, which might be understood to be a relatively low setting on that dial, where what we're looking for is transparency and honesty. But it extends to regulating any kind of conduct here. And one of the interesting things about the conduct it's regulating is it's not just about the content of the information that's being provided, it's also about how the information is being provided to people. And in the ACCC and Google case, one of the interesting things, if you look at that judgment, one of the interesting things the court considered was the choice architecture. How people were actually provided the information and given the opportunities to respond to the options available to them. So what constitutes fair processing here, what is fair and reasonable, is determined not just by the information that's being provided to people, but also the choice architecture of the app or the website. And that also can be unfair in the way in which it is creating or nudging people towards particular kinds of choice. So we've got consumer law in Australia doing some of this work, but we also have privacy law in Australia. It's not called data protection law, it's called privacy law. We have it at federal, Commonwealth and state and territory level. The Privacy Act 1988 is the Commonwealth piece of legislation which regulates Commonwealth federal agencies and private organisations, unless a particular exemption applies. The Privacy Act is a series of sets out a series of Australian privacy principles, and the Australian Privacy Principle 3.5 states an APP entity must collect personal information only by lawful and fair means. So the word fair enters the landscape of Australian privacy law through the Privacy Act and APP 3.5. APP 3.5 requires that an organisation subject to the Privacy Act must collect personal information only by lawful and fair means. That the regulator's given guidance on what this means, and the regulator says a fair means of collecting information is one that doesn't involve intimidation or deception, and it is not unreasonably intrusive. So we can see in that guidance, we can definitely see that first setting on the dial, transparency, honesty, intimidation or deception is certainly unfair, but we also see a movement towards a second setting on the dial in relation to unreasonably intrusive. The guidance says whether collection's unfair is going to depend on the circumstances, and they give a couple of examples here. Now, what I'm going to note about this is that the responsibility to act fairly is limited to the collection of data and is limited to the collection of data by unfair means. Now, I mentioned at the outset the Privacy Act in Australia is currently under review, and the regulator, the Office of the Australian Information Commissioner, in their submission to the review process, has noted that the fairness concept only has limited recognition in APP3. The OAIC's, the regulator's experience indicates this protection doesn't go far enough. Because it only applies to the means of collection, this requirement may not prevent other inappropriate practices. While a collection may not reach unfair means threshold, such as collection through deception, there are collection practices which are nonetheless unfair in that they adversely affect rights and interests. So the regulator in Australia has recognised this fair processing requirement that prohibits unfair collection by unfair means doesn't go far enough. And they suggest changes to Australian law so that the collection of personal information must be fair and reasonable in the circumstances, and also the use and disclosure of personal information must be fair and reasonable in the circumstances, even if an individual consents to the collection. Now, one of the things we're going to be wanting to consider is the relationship between a fair processing requirement and consent. If an individual has signed up, understanding what they're getting themselves into, what bearing does that have on an understanding as to whether or not the processing was fair? Well, here the regulator is clearly signaling that they think a fair processing requirement has to apply regardless of whether or not an individual is giving consent. With or without consent, you need to be able to assess independently whether the processing is fair. Okay, so this is what the regulators proposed with regard to the reform of Australian law. But if this reform were to be enacted, then Australian law has to decide what fair and reasonable is going to mean in these circumstances. If it's going to go beyond a requirement not to deceive and intimidate, what is it going to require? Well, there's been an indication here that Australia also is looking at Europe and looking at the GDPR and looking to see how fair and lawful processing is interpreted and understood over there. So I'm going to come to the end now. I'm just going to quickly mention how this is understood in the UK Information Commissioner's guidance. This was drafted whilst the UK was still a member of the European Union. Let's not go into that right now. But as I'm sure you're aware, Article 5.1 of the GDPR is the article which states that personal data shall be processed lawfully, fairly, and in a transparent manner. So fair here means something more than just lawful, more than just transparent. Fair is adding something to the requirement of transparency. And the ICO guidance on this says, in general, fairness means you only handle personal data in ways that people would reasonably expect and not use it in ways that have an unjustified adverse effect on them. You need to stop and think about how you can use data, but also about how you should use it. Now, within the commentary that the Australian regulator has offered in relation to the proposed reform of Australian law, they pull out a couple of potential tests that include the reasonable expectation test to inform and supplement an understanding of what fair requires, and also this notion of unjustified adverse effects. So there's a recommendation here that we move at least to that second setting on the dial, where fairness requires more than just transparency. It requires more than honesty and doing what you said you would do, although that in itself is significant, just that. As I noted, the ACCC has taken action against the Health Engine case and Google in circumstances where the organisations were not doing what they thought it was reasonable for a consumer to expect them to do because of what they had been told. So they thought they had been misled in those circumstances. So even that first setting on the dial has significance to it. But here there's recommendations to go beyond that, to say that you cannot process data in a way which is going to have an unjustified adverse effect. Now, in other guidance in relation to big data, artificial intelligence, and machine learning, the ICO has looked at what fair processing means in the context of big data. And in that guidance, the regulator said, if big data organizations are using personal data, then as part of assessing fairness, they need to be aware of and factor in the effects of their processing on the individuals, communities, and societal groups concerned. So when one's looking at what fair processing means, one looks at notions of reasonable expectation, and one looks at the notion of an unjustified adverse effect, one then has to consider the scope of those upon whom effects will be considered relevant. Is it just an unjustified effect on the data principal, or is it an unjustified effect on the data principal's family, their community, the public of which they are a member? And through this, a requirement for fair processing can extend beyond a requirement that you do not act in a way which leads to an unjustified harm to the individual, but you can begin to bring in societal considerations and questions of social and societal harm. But then just to finish, that then opens up further questions, because then it's not just a case of where do we set the dial in relation to 1, 2, and 3. but it's a case of whose interests become relevant when one is calculating whether or not any particular setting on that dial is satisfied. So even if we move to the second setting and we require only proportionate interference with fundamental rights and freedoms, we only require, if we only permit adverse effects insofar as they're necessary and proportionate. Proportionate to what? Proportionate to the harm that an individual might experience, the interference with the individual's interests, or proportionate to the public or the social harm that might otherwise result. So these are some of the things which have to be determined within that broader conceptual frame that fair processing sets up. Thank you. I look forward to discussing this with you.
Thank you very much, Professor Taylor. That was an absolutely interesting view of the gradients, a very fine-tuned set of possibilities within which fair and reasonable processing can be done, and it certainly provokes a lot of questions concerning what are the best ways of achieving fair and reasonable processing. With that, I will move on to our second speaker for the day. Our next distinguished speaker for the day is Professor Dr. Altaf Marsouf, Assistant Professor of Law, attached to the Division of Business Law at the Nanyang Business School, Nanyang Technological University, Singapore. Prior to this, he completed his doctoral research on Internet intermediary liability for trademark infringement, and his doctoral research was the basis of his book titled Internet Intermediaries and Trademark Rights, published by Routledge in July 2019. Today, Professor Marsouf will discuss consent, transparency, and accountability, data protection in a world of artificial intelligence and IoTs, an issue which is of great contemporary relevance. With that, I will request Dr. Marsouf to please address the gathering.
Thank you very much, Krishna. Can you hear me?
Yes.
Yeah, wonderful. Thank you very much, Krishna, for that kind introduction. I think that I would like to start by thanking the organizers for putting this event together, because I feel that we are in circumstances where it is certainly warranted that we talk about privacy and data protection. And as Mark alluded in his presentation, I think people are increasingly utilizing online platforms today to communicate with each other. And we are sort of exposing ourselves in the online context, becoming more and more vulnerable. Just yesterday, there was a news report in Singapore from where I am that there has been an exponential increase in online frauds and scams, which specifically target consumers based on their personal information. And we have also been hearing a lot of breaches of, data breaches taking place as well. So I think that it is very important that we talk about privacy and data protection. And indeed, I also was closely listening to Professor Taylor's presentation, where he spoke about reasonableness and fairness in the processing of personal data. And I think what I would like to do is to perhaps add to that discussion by further buttressing his argument that we need to rely more on fairness and reasonableness standards, particularly because of the way in which technology is evolving today. So let me share my slides to sort of take you through. I'm sorry, let me see. Yeah, are you able to see my slides?
Yes, we are.
Okay,
Thanks.
great. Okay, so in essence, I thought that I would begin, I would begin with the concept of the fundamental concept, which I call the trinity in data protection, which essentially is consent, accountability, and transparency, right? And I think Mark alluded to some of these concepts in his presentation as well. But in essence, I think that consent and transparency are still very important ideas when we are talking about privacy and data protection. So what does it really mean to give consent? And I think this is an important question that we need to perhaps address simply because we have certain expectations. And unless we are able to meet those expectations when we grant consent, I think then there's going to be a problem, right? Um, so when we consider the idea of consent, it is by no means something which is unique to the concept, to the area of data protection. It is a much more universal concept. It perhaps is the portal by which we can legitimize our interactions with third parties, you know. So it's a very important concept that goes to the heart or even root of every interaction that we have with society. So therefore, consent is a very important idea. But what does it mean to give consent? And in the words of some of our greatest philosophers, they have suggested that we need to be able to give consent freely and voluntarily. So, for instance, Hobbes, in the context of contracts, has said this, that mutual agreements has to be completely voluntary, right? And in the context of political theory, Locke has said that consent must be fully voluntary and it should represent the free will of the individual concerned and not the will of anyone else. So these are some of the key words that I think sort of underpin the meaning of consent, really. Um, and but in the context of privacy and data protection, I would like to argue that you are not going to be in a position to exercise your free will unless information is presented to you in a certain way that you're able to make that choice in a responsible way. So once again, I think Mark had stated this with reference to the ACCC and Google case that took place in Australia. And I feel that to a great extent, transparency in this context is very important because unless data controllers or organizations that make use of our personal data are transparent and completely upfront with us in how they are going to be using our personal data once we disclose it to them is very important before we could decide whether or not we give consent for whatever the purposes for which consent is being sought. So in that context, I think that for consent to be truly informed and hence a free exercise of someone's choice, there needs to be a degree of transparency, and that's why in the triangle we would see that transparency and consent interact and interface with one another. And of course, all these concepts are held together are held together through the notion of accountability, right? You need to have certain legal sanctions imposed in order to make sure that those responsible for our data are held responsible and accountable, particularly when things do end up going wrong. So to that end, I think that these three concepts are very important in relation to the protection of privacy and data protection in the online context in particular. But having said that, I would like to say that the legal texts, I mean, if you look at the legal texts that you would see on your screen right now, I think that these concepts are very much enshrined in all of these legal instruments, starting with the 1980 OECD guidelines, which I think influenced many of the laws, and of course the EU GDPR, which is probably a model that has been utilized to frame laws in many other jurisdictions, right? So I'm not going to go into detail because I think that these are concepts that are already known to most of you. So I think that it is just something important to note that the concept of consent, transparency, and accountability are very much enshrined in data protection laws that we already have. So what is really the problem? I think that the problem arises because of how technology is evolving in today's context, right? We are no longer in the scenario where we walk into a physical building and we fill in a document and sign it and hand it over to someone to process our data and provide us with some kind of service. We are far beyond that now. In most occasions, we do not even know who exactly is on the other side of the network that we are dealing with, right? And also, we are dealing with scenarios where it's no longer one-to-one transactions. It's often one-to-many, if not many-to-many dimensions of transactions that are taking place cross-border and with so many numerous intermediaries coming into the picture for technical reasons and or legal reasons. So we are dealing with very highly complex transactions in today's context. And therefore, in this context, I believe that even if someone were to meet the transparency requirements by providing data subjects with all the comprehensive information that they require to make a responsible choice, a reasonable data subject with some degree of knowledge about the internet may find it difficult to fully comprehend about what the contents of the notice or information provided to them are truly, right? And for that reason, I think there are many challenges in meeting the transparency obligation, and hence there is some doubt whether we are really consenting in a way that meets our true expectations of consent. And not to mention the fact that often we give consent by checking a box in circumstances where we are almost coerced to do that within a time frame with a clock ticking and a transaction is pending and we need to go through the transaction. Otherwise, we need to restart the whole process, which is hassle. So it's human nature that we simply go ahead with the transaction, right? Also, we are heading towards, devices that are all interconnected to one another. So people talk about IoT or Internet of Things. We are already there. My headphone is connected often to my mobile device, and my smartwatch talks to my phone and transmits data to various service providers, right? And in this context, some of these devices may not even have the means to communicate with us or have the display or the panel, the interactive tool to enable us to give consent or for that matter, provide us with information necessary for us to exercise our consent, despite the fact that we are actually advancing in technology. So the devices that we are dealing with are becoming, in a sense, dumber, although they are in an interconnected network, doing very useful things for us. So we need to think about that as well. And I think this was, again, something that Mark mentioned, the incorporation of artificial intelligence for automation purposes. Automation is a great thing, but there are some challenges with this because AI comes with machine learning and so on, and they can evolve over time. The algorithms are at times unexplainable. And they call it the black box. And therefore, in circumstances where AI is being used to process data and something does go wrong or an outcome requires an explanation, data controllers may find it difficult at times to explain the outcome simply because the algorithms are not all that explainable in that context, or they cannot discern as to how the outcome was reached. So we could have some of these challenges being posed at us when we are advancing in technology, which gives rise to a question as to whether we can solely rely on the concept of consent, transparency, and accountability alone. So for that reason, I completely agree with Mark that reasonableness and fairness will, in my view, too, play a huge role in ensuring that the data subject's interests are protected. And I feel that the triangle that I represented earlier in my first slide should be replaced with this, in a sense, because that would be an important sort of node so to say, in the interaction. Now, the reason why I placed fairness at the bottom of this diagram was with some reason. I feel that that standard would actually support the idea of consent and transparency. It is not going to be something that completely replaces those standards, but I think they would work together. But at the same time, I think that they should also be independent. The reason why I would say that is because, as Mark did mention in his presentation, we are going into a situation where we cannot rely on consent and transparency any longer, and we need to therefore safeguard the interests of data subjects by using the fairness and reasonableness standard. So we need to be relying on that standard as a basis. And also, I feel that fairness and reasonableness would also have an important role to play with regard to how we ensure that data controllers are held accountable as well. But I want to make one point about accountability in this context. And that is one important way in which accountability could be achieved is through this idea of privacy by design and default. I think this is a concept that is engraved in most data protection regimes, and most certainly the EU GDPR, as you can see. And I've highlighted in this slide the two provisions in the EU GDPR which deals with this concept, right? And as you can see, Article 2 and Recital 78 of this particular, of the GDPR focuses on data controllers, right? So the data controller shall be responsible to make sure that they comply with the notions, the privacy principles, the data protection principles in regard to their choices of technologies that they're going to use, as well as the organizational regime within which they will be processing and collecting data and so on. But when it comes to those who actually develop the technologies themselves, right, which are often not the data controller itself, they could be third parties involved in the design and development of these technologies. But when it comes to those entities, the GDPR simply says that producers of products, services, and appliances should be encouraged to meet the minimum standards required under the GDPR. So there is no, it's not mandatory in any sense, but it's just encouraged. I feel that this is a bit of a gap that needs to be addressed because often data controllers will be using third-party technologies, and particularly when things go wrong, and certainly if AI is being used, and when it comes to having to explain to authorities about certain things, I think the data controller may not be able to fulfill its obligations fully if the technology itself isn't transparent enough and designed in that way. So I feel that we need to also address the fact that designers of technologies should be bound in certain ways to meet the privacy by design and default standard, or at least think about it at the time of designing their technologies. Now, to a great extent, the EU's latest proposal, which I think came out in the middle of 2021, so this year, where they are hoping to harmonize rules regarding the use and design of artificial intelligence technologies, could address this gap to some extent. So if you look at this if you look at this AI regulation or proposed regulation, Article 1 specifically talks about both the users and providers of technologies, right? So users are, by analogy, the data controllers, and providers of the technology are, by analogy, the people who produce products and services, right? So I think that the AI regulation captures some of these things, and the AI regulation specifically deals with things like meeting transparency, explainability standards, ensuring that there is human oversight. So, for instance, when it comes to, granting consent and so on, I think that's an aspect of human oversight, right? Because when you are intervening to interact with the technology, that is an opportunity for you to sort of control how the technology functions. And I suppose notice and consent is an aspect in that sense of human oversight of the technology and how it is being deployed and used. So there are certain obligations with regard to human oversight requirements. And of course, the requirement that the technologies must be accurate, robust, and secure. So these things are good developments that are taking place in the EU's context. But that said, the AI regulation is limited to certain high risk users of AI. So it's quite limited in terms of scope in that sense. I mean, it captures the more risky situations, whereas I guess the GDPR applies to a far greater number of situations that common people like you and I would be dealing with. So I think there is still a gap that exists, and perhaps I suppose the framers of the GDPR may need to think about whether they could learn from these new proposals from the EU with regard to the regulation of AI and implement those in the context of data protections more specifically, perhaps. So I think that doing that could address some of the questions and gaps that I was trying to address. So I think in sum, I would like to sort of conclude by saying that when we consider the trajectory technology is, taking us, I think it is time that we pause and think about, firstly, what our expectations of privacy and data protection are. Do we really need consent in that sense? Are consumers even, concerned about it at all? Because humans evolve, our expectations also evolve. So if consent is no longer something that is something important to us, is it something that we need to keep within our legislation at all? But of course, I think to most of us, consent will be an important notion, at least for now. So I think that's one thing that we need to think about. What are our expectations? Secondly, because of the way in which technology is evolving, I think that we need to move away from our traditional focus and shift towards ensuring the standards which are fair and reasonable, so that despite our consent, as Mark was saying, referring to the Australian Information Commissioner's proposal, that despite your consent, that the processing of data has to be fair and reasonable. I think that is crucial. So I guess I will end with that. Thank you very much.
Thank you very much, Professor Masuf. That was indeed a very insightful talk, and I particularly enjoyed the perspective that you provided concerning how we can compare GDPR with the recent proposal in the area of AI regulation, and perhaps that could help us address some of the gaps that exist in GDPR. So thank you very much for that. And once again, your talk has evoked many questions, but due to paucity of time, we shall move forward, and I will move on. Our next distinguished speaker for the day is Professor Dr. Jeannie Mary Peterson, Professor, Melbourne Law School, and Co-Director, Center for Artificial Intelligence and Digital Ethics. Professor Peterson specializes in the areas of contracts and consumer protection, along with the law of emerging technologies. Today, Professor Peterson will focus on the concepts of data fiduciaries and data controller, the principal regulated entities in the data protection framework. With that, I would request Professor Dr. Peterson to please address the gathering.
Thank you so much for having me. I'm delighted to be here, and the two previous talks have been fantastic. And although we haven't actually coordinated, I think that what I will have to say feeds nicely off them. I just wanted to check how we're going for time. Have we still got enough time, or do you want me to talk for a bit less, maybe?
So, Professor Peterson, we do have time till 2:45. That means that even if we wish to leave 5 minutes for a Q&A, we still have 35 minutes. So,
so is there another
around...
speaker Is there another speaker after me?
Yes. Professor Sharma will be
okay.
addressing us. So we will have
Okay.
15 to 20 minutes for each of you.
Okay, thanks so much. I'm just going to share my screen. We're in a different time zone here, so I'm constantly confused about how we're going time-wise. Great. Can you all see that now? Excellent. Okay, so I'm going to thank you. I'm going to speak about data fiduciaries and data controllers, which builds well, I think, on the themes that have already been raised about the limits of mechanisms of notice and consent in protecting the interests of consumers or data principals, and the interest in imposing broader and more substantive obligations of fair and reasonable conduct on data controllers. And I'm going to look in particular at the suggestion that's been raised in India in its proposed legislation for imposing more onerous, I think, or more demanding obligations on data controllers. So under the GDPR, the key obligations sit, of course, on data controllers, and that's the person or entity that makes the decisions of the purposes and the means of the processing of personal data. And data controllers have to comply with the GDPR data principles, and they're set out there on the screen. And they're responsible for complying with those principles and essentially operating within the parameters set by the GDPR to both keep the interests of the data principles protected and also to essentially oversee the actions of the data processor. Now, under the Indian Personal Data Protection Bill, the concept of a data controller is replaced with the concept of a data fiduciary. So you can see from the definition, they're performing the same role as a data controller in the GDPR, but with this different language of fiduciary. And the data fiduciary, like the data controller, has obligations to comply with the obligations under that proposed legislation around the processing of personal data, the way in which it's collected, the standards through which it may be used, safety and security requirements. Now, it's interesting, I think, that this language of the data fiduciary has been used. I'm going to talk about the way in which the concept of fiduciary sets a quite high standard of conduct on the party who is the fiduciary. And yet there are protections within the Indian personal data protection legislation that would seem to cover the field and look after the interests of individuals. So, for example, there is an obligation for fair and reasonable processing of data to ensure the privacy of the data principle. And as has been discussed by the two previous speakers, there's also an emphasis on consent, so that in one of the bases for collecting and processing data is consent, and there's quite robust requirements on consent, which would seem, at least on its face, to provide sufficient protection for individuals whose data is being processed. And yet we have this concept of the fiduciary in the Personal Data Protection Bill. Now, what it seems to do, what that use of the fiduciary concept seems to do, is go further than simply relying on consent for processing of data to protect individual interest, and indeed possibly even go further than simply referring to fair and reasonable processing as a procedural obligation requiring transparency, the first dial on Mark's schema. So the use of that word data fiduciary suggests that the data controller should genuinely act in the interests of the data principal, the individual, that fair and reasonable processing is more than just a procedural obligation requiring transparency, and that even if consent has been obtained from an individual, that does not justify processing in ways that may be harmful to the welfare or interests of the data principal. And here, to make this a little bit more concrete, we might use the example where perhaps a social media company has collected data from a person who would like to use that platform. There's been extensive disclosure of what's necessary, what's going to be collected, what's going to be done, and yet the data that's collected may be rebundled and used for various types of advertising that may eventually act against the interest, for example, of the individual, perhaps by manipulating certain vulnerabilities they have to sell them products that are too expensive, or perhaps by understanding the price range that they will pay for services or goods and ramping up that price, or perhaps by using that information to deny credit or increase the cost of insurance. We can see lots of possibilities on an individual level, and Mark has also mentioned the impact on group interests. So this suggestion for the fiduciary, who will go further than the consent mechanism and go further than a mere concern with transparency, came out of the report by Justice Sri Krishna that led to the Personal Data Protection Bill. And the committee there was very alive to this tension between wanting to give individuals autonomy but also protect their interests. And so it recommended that there should be meaningful consent to individuals participating and sharing data, but to protect individuals or data principals, there should also be substantive obligations imposed on data controllers. Now, in the general law, the judge-made law, the concept of a fiduciary is quite a particular one, as I know you will all be aware. It's more demanding than a contractual relationship. It demands strict loyalty from the fiduciary to act in the interests of the other. So it's not just a contractual relationship, it goes further than that. It carries obligations of loyalty to avoid conflict of interest, to act in the best interests of the other party. And so the use of that language seems to invoke those standards. And we know that that's the case because, in fact, Justice Sri Krishna's report was very influenced by the work of an American scholar, Jack Balkin, who wrote a very famous article called Information Fiduciaries and the First Amendment, which discussed many of the themes in our wonderful previous presentation about the limits on consent mechanisms to really ensure respect for individual autonomy and welfare as a basis for processing data. And Jack Balkin noted those principles that, there's information asymmetries between firms and individuals. It's difficult for individuals to verify and oversee the claims of firms, and individuals can be said to be vulnerable to firms with whom they're dealing and who may be collecting or processing data, and to place trust and confidence in those firms to act in their best interests. And all of these are indicators of the kind of relationship in which fiduciary duties may apply. And hence we see in the Indian personal data protection legislation a statutory concept of the fiduciary. And it came through very clearly in the report from Justice Sri Krishna that we would have this idea of fairness, respecting and protecting the rights of the individual in circumstances where there were extreme inequalities of bargaining power. And the fiduciary concept would somehow mitigate that inequality. And then hence the idea is that data fiduciaries under the legislation would only be able to share and process data in a manner consistent with the expectations of the data principle. And then the idea here is that will protect both individual autonomy and also promote the common good, that we'll be able to have data flows to benefit the economy, but not the sort of exploitation or manipulation that is such a concern with the sharing of data. Now, the concept of the data fiduciary, though it's embodied in the legislation, has been also criticised, and in particular, Lena Khan and David Posen wrote a very critical article of the concept that was published in the Harvard Law Review. And what they said is that it's all very well to say that a data controller is a fiduciary, even by statute, but that sort of glosses over a fundamental tension in the relationship between an individual or a data subject or a data principal and the data controller, which is that the data controller is collecting data to make a profit. It wants to monetize that data by, for example, using it in advertising. And that idea of the data controller or data fiduciary using the individual's data to make its own profit is fundamentally inconsistent with the idea of a fiduciary who's supposed to be sort of self-effacing and acting in the interests of the individual. And they are also concerned that given the market power of a lot of firms, it's just unrealistic to assume that firms will act in a fiduciary way or that there's any way of enforcing them to do that. And here we come to what I wanted to share or prompt you to think about, which are alternatives to data fiduciaries as a way of protecting what we all seem to agree is an important interest, that of promoting fair and reasonable processing of individual data. So we've seen the suggestion for a data fiduciary, and we've also noted that it carries some tensions and perhaps ignores the market power of digital platforms and other large firms that may play lip service to this requirement, but there's very little way to oversee and scrutinise them. So the alternatives are listed on the screen at the moment. So one of them is the idea of data trusts, which is where a third-party entity holds individual or group or community data and therefore oversees and scrutinises the use that can be made of it. Second suggestion is to give individuals better control, stronger mechanisms for actually managing consent for data uses. One of the problems that's often raised about relying on consent is that individuals get overwhelmed. There's too many consents, too many terms. One of the suggestions we see in Australia under a piece of legislation called the Consumer Data Right, which aims to encourage consumers to be empowered to transfer their data for various uses that will benefit them, is an idea of a consent dashboard. So consumers can actually see what they've consented to and have a real practical mechanism for withdrawing consent at any time if they're not satisfied with the outcome, and indeed a sunsetting of consent so that it's not a once and for all thing. Another possibility discussed by Dr. Taylor or Professor Taylor is to have stronger protections and remedies against misuses of data. So just to ramp up the force of consumer protection law and regulatory oversight. For example, unfair contract terms law, as we see in the EU, can be used to strike down overreaching or unfair terms or notices that seek to take too much data or unreasonable terms for consumers. And then lastly, we've got laws on the uses of AI, such as the EU AI law, which has just been discussed. Now, I'm quite hopeful actually about the scope of that law. It was interesting to see here the previous comments about it, because I think I take the point that it focuses on high risk systems, but I guess coming out of that, what is the point Professor Massouf made, which is that depends how you define high-risk systems. So certain types of uses of AI feeding on data, if they're high-risk systems, there's quite scrupulously robust requirements for keeping an eye on the way those systems work, including auditing of outputs, so that we can see if there's bias or discrimination or self-serving behaviour in those AI systems. But even in the limited and minimal use AI systems, which are things like chatbots, and that's some of the IoT devices that were just discussed, even in those low impact systems, this legislation, the EU AI proposal law, would in fact at least require a high degree of transparency, I think, in the way those systems worked, in the sense that people would have to be informed about the operation of the system and given some scrutiny and oversight of it. So just to conclude, as the other speaker has suggested, it's important to realise that consent is an important mechanism for empowering individuals, but we probably need to do more to protect individual interests or the interests of data principles. We can do that by putting more obligations on data controllers, making them fiduciaries, and we can also think of mechanisms that sit outside that relationship between data controller and the data subject, which allow greater scrutiny and oversight by regulators, in particular, of the uses that are being made of data, particularly, as been mentioned, when that data is being used to inform and train AI or machine learning systems that are otherwise the individual has very little hope of responding to. What we can put in place mechanisms for regulatory oversight of those systems. And that's probably all I wanted to say. So thank you, and I look forward to the conversation.
Thank you very much, Professor Peterson. First of all, for clarifying the differences between the philosophical underpinnings of data controllers on one hand and data fiduciaries on one hand. And it just tells me that there's no good reason for using these two terms interchangeably. Also, with the challenges that exist with actually enforcing the data fiduciary standard and the alternatives that you have presented. That's a very insightful talk, and we will certainly want to come back with certain questions and discussion points. However, for the time being, I shall move on to our fourth speaker for the day. Our next distinguished speaker for the day is Professor Dr. Nandan Sharma, Professor and Head at the School of Law, Faculty of Liberal Arts and Management Sciences, Shulini University, India. Dr. Sharma holds a doctorate in the field of intellectual property rights, and his research interests include cyber crimes, human rights, and privacy. Today, Professor Sharma will address the conceptual understandings of data privacy framework with a focus on the right to be forgotten. With that, I will request Professor Dr. Sharma to please address the gathering.
A very good afternoon. Hope I'm audible, Krishna.
Yes.
Yes. So very, very good afternoon, warm good afternoon to all my dear legal luminaries, a galaxy of legal luminaries, I can say, who have joined together. And what a wonderful day to have discussed the theme, basically today, of the conference, the road ahead in implementing personal data protection legislation effectively, lessons from EU and beyond. So I'm privileged and honored to share the dais along with Professor Jenny, Professor Altaf, Professor Mark, Professor Indra, and others who have joined today. And I was even listening to the speakers of the inaugural session. So I'm probably the last but not the least speaker of this session one. So most of the things might have been covered by my earlier speakers also, but still I'll try to give something new that I can give today. Although I'm not an expert in this field, but yes, now we are living in the technology age. We are living in the times of pandemic for past 2 years now. So obviously this becomes one of the most good topics, most debated topics to discuss the globally, I can say, right? So basically, I would just start by beginning with a little bit of introduction that how this concept of privacy developed in our country, India, basically, and also with the bird's eye view of the GDPR and how it basically dwells in with our own PDP bill, 2018 and amended in 2019, I can say. So this is how we can begin. So this is a brief snapshot of the journey that next 15 to 20 minutes I'll be spending with you. And very hurriedly, I'll try to skip over the things that have already been discussed by my co-speakers, right? So we all know now that, as I told, that the digitalization has become very, very important. Right from the morning when we get up from our bed and lie till our sleep, we are governed by technology today. Every aspect, believe me, uh, of our beginning with the day, beginning with our business, beginning with our academy, or anything we can say, the pedagogies of teaching, the pedagogies of shopping, the e-commerce, everything we have a word E attached with it, right? So that's what makes the privacy part very, very important. So we are discussing for last 2 hours on this personal data, right? So I think data becomes the most valuable aspect of the human, and somehow it has become so valuable that it is even more rich than the human being himself, we can say, right? It is very, very, and if we talk about the personally identifiable information, right? So there are various aspects to privacy, my friend, right? There are different privacies. Privacy can be of our personal data, of our any other types of data, of the information, of our bank accounts, of anything. Everything we are including within this privacy, right? So basically what it includes. So in a nutshell, it includes of the person, of personal behavior, or of communication, or we can say most importantly of personal data. So that is what something we are discussing here today, that is upon personal data. Our main concern today is about personal data. So yes, India also becomes very, very crucial here when we talk of our subcontinent here, because we are one of the biggest consumers of this IT related thing, right? India is one of the, globally, it is one of the biggest consumers of the technology, user of the technology, we can say, right? So this relationship, how this relationship begins, I'll be also coming to the judicial perspective, but before that, a relationship just begins either with a mobile or with a computer. And just as my co-speaker, Professor Mark and Professor Altaf was also saying, that everything is interrelated. Our smartwatch, our mobile, our technology, our laptop, our everything, our slides today, everything is related. And just with the one click, and that too is time linked, right? My dear friend Professor Zahid rightly said it is time linked. We do not want to go back to that hassle of that process. So it depends that how important this consent part becomes, that becomes very, very important. So privacy is rightly connected directly with our consent, right? So when we just click on, we are giving an implied consent there, and how much time, how much energy, how much uh, basically mind we are devoting to just go behind that and try to analyze that for what we are consenting, right? So that's where somehow this concept evolves. Again, going to my previous speaker, Professor Jenny also stressed on that little bit, that how it evolved in the, basically in the impact of this judicial pronouncement, right? So I can just stress that this Khadak Singh judgment, right? Or basically, if we talk about the MP Sharma versus Satish Chandra, they have been the judgments that initially were not in that favor of the privacy norms of India, and they excluded it from the purview of Article 21 of the Constitution of India. That means at that time the technology part was not that much into forefront, and obviously the jurists thought that yes, no, it might not be a part of privacy, but yes, somehow the dimensions kept on changing, right? Years and years, as we became more and more dependent on the technology part, it is now becoming one of the most important feature of our life. So that's how the judicial temperament changed, right? And if I go with this chronology of some of the landmark cases of our Indian continent, so basically in A.K. Gopalan, or with the MP Sharma, Khadak Singh, or R.C. Cooper, the temperaments on the other side of the table, but it changed soon as we talk about Govind versus state of MP, or Raj Gopala versus state of Tamil Nadu, and finally with K.S. Swami verdict. The judgment, which was also discussed by Professor, the inaugural in the inaugural address by Professor Mohan Kumar also, right? So this is why we are discussing this topic today in this country, right? See, the basic concept, that the concept of privacy was totally changed by this Putta Swami judgment in 2017, and basically it stressed upon, it held series of discussions, deliberations over the past 70 years of our journey right after independence, and they try to analyze on these three important aspects, right? How is it protected? Whether right of privacy is protected under the Constitution? If yes, is it a part of right to life? And what are the doctrinal foundations, right? So this was primarily the major cause of concern for this judgment. And finally, they came up that yes, it is a part of the Article 21 of the Constitution of India. It is a natural and inalienable part here. Very, very important part, that they said it is the inalienable part of right to life and personal liberty, as we all know today. I would just like to highlight one of the most important part, that informational control over personal information. That is what I am concerned basically, and that slowly in next 5 to 10 minutes I'll go to right to forget also, right? So this was the main part. Obviously, these are some of the paragraphs, as Professor Mohan also suggested, that everyone should go by the judgment. So I tried to go down, although it was a very lengthy judgment, but I tried to go down the various paragraphs, and it was very, very interesting to notify that how the things develop, and they are becoming a part of our main right to life and personal liberty. So these are some of the things. So privacy is a constitutionally protected right, which emerges primarily from the guarantee of life and personal liberty, right? So this is what was majorly suggested there, right? Basically, they also say that it is basically not an absolute right, though, because as the earlier speakers also said, it is nowhere directly mentioned in our constitution. That what is basically privacy has not been defined in the Indian constitution, but yes, a dimension has been added to Article 21. Right. So, friends, from here we also see that what the judges feel. Judges also feel that privacy is concomitant of the right of individual to exercise control over personality. This was suggested by Justice K.K. Paul and Justice Bobde said that conquered personal freedom is a state of mind where one is free from intervention of public or private and is free to act according to his choice. So this is what we are discussing. That are we acting to our choice? Is our data going by our own choice, right? Even if it is in our country, or it is being stored here, or if it's going to other countries, is it by our own choice? Who is governing that data? So basically, the things were the same. The things were that there are three things basically that are very very critical. That who owns this data, and as was suggested by Sir also, that who monetizes this data. Right? Now I come to another very crucial part, and here where I would like to differentiate between the GDPR and also between the Indian bill here on the right to be forgotten. Right. So basically, the concept has been imbibed in the Personal Data Protection Bill 2018 in our country also. That, but it has the title somehow does not match with the provisions underlined therein. Basically, the right is very simple that if I want that my data should not be shared, or I want it to be curtailed, or I want that it should go by my own wish, I have the right for it to be removed from that repository, from the fiduciary, and that is what the consent of data principle implies. So when I'm consenting to share the data, I'm also consenting that I have the right to be forgotten. Right. So, but is my right to be forgotten absolute in nature? Right. Do I have this right particularly in my hand when I see that, when I say that, yes, this is the data which I have shared, I have given consent actually, but do I have the control over that data? Right. So this is how the right to be forgotten was initiated. The discussions were initiated, and it was included. So both the fiduciary and the data principle, both have been given certain rights and principles within the bill of this PDP bill of 2018. Right. So although we also talk now about personal data, sensitive data, and the critical data, which types of data can be shared, which type of data can be only stored, and which typically cannot be shared with the other country. Also, it can only be stored in Indian data fiduciary we talk about. And we also have a data protection authority, as my co-speakers also suggested, that just like the EU framework, now we have the data protection authority, DPA, that is looking to all the scenarios of this data protection today of the country. Right. That's another issue, that when this bill will see the light of the day. But we obviously know that going forward, yes, this bill would be materializing, and we will be having some privacy norms in the country. So now the thing comes, is the bill catering to the right to be forgotten in the truest sense as has been provided with the EU or not? So these are the three sets of data, as I suggested, that we are typically providing now as per the latest bill also of 2019. That is the personal data, the sensitive personal data, and the critical personal data. I'm not going into the details that what these three typical data mean. We all know personal data is very, very simple. That is our personal details, right? Not much to worry, because as Sir also told initially, that this data can be shared also and can be transferred also. Yes, sensitive personal data is something very critical. It comes when we had talked about our every detail about our reproduction, about the religion, and all the other details of our bank details, of our biometrics, and everything becomes very, very crucial. And that's somewhere again the right to be forgotten comes into play. Right. And similar is with the critical personal data, that is most critical, and that is obviously depending upon the security of the country, right? It becomes most critical, right? Clear? So basically, we all know that the Basic Principle Act, that is the IT Act of 2000, and typically Section 43A governs, had used to govern basically the personal data. It was regulated by that, and now after having seen past 2 decades that how this act is governing and whether it is effective to control the personal data, that's why this bill is today being tabled in the parliament, right? So now we have that section 27 that basically deals with the right to be forgotten, right? And right, it is basically a right of the data principle, as I told you. I told you that data fiduciary and data principle both have certain rights, both have certain obligations. So this is a right typically in the hands of the data fiduciary. That is right to be forgotten. So the basic thing is that we have a set procedure, set format that we have to apply on a prescribed format for this right to be forgotten. And where this is the point where we deviate basically from the EU framework. We deviate from the GDPR here only in this one aspect, right? So we can say that yes, the right has been provided. We can apply, and the application or the basically the control of that application goes to the adjudicating authority, right? The adjudicating authority, as suggested here, has the authority that it will give you the go ahead whether to go ahead with the to erase the data, or we can withhold. So that's the basic touch point. So in a sense, we are again engaging ourselves in the same thing, that if we there are some regulatory frameworks here, I can say, or adjudicatory frameworks here, right? So basically, we are increasing the time lapse, right? We are increasing it by maybe months or years also when we say that authority comes in between and some set procedure comes in between. I will also go that now I come that how we are comparing, if we compare it with the GDPR now. So basically, the only difference between the two things, the GDPR and the bill, suggests that we do not have a typical right of eraser here as has been provided in the EU format, right? So there we the co-speakers also said that basically when we talk about that erase, we all know that it is without undue or without unreasonable delay. This right has been provided by the EU framework without unreasonable delay. And by incorporating the adjudication or the adjudicating authority, or by prescribing it up within a strict format and then applying, we have put some delays in between, delays and latches. So there are chances that tomorrow this provision, one of the finest provisions that has been given, it may all again turn out to be a toothless tiger, right? That we might not be able to provide the justice, provide this right within a basic time framework, right? So basically, so that what the comparison suggests, that we also can go with the right of erasure in the similar manner, the right to forgotten in the similar manner as per GDPR, which suggests that it is without the same undue delay as I have suggested here also, right? Basically, this delay under the EU GDPR is delay here basically has been taken into 72 hours. And also there is the obligation there that uh, you have to even suggest, or you have to even give the feedback there, that what basically has been done to erase or remove that data. Has it been done or not? That ironically has not been put in the Indian bill of this 2018, right? So this is some of the fact find that based on the comparative analysis or based upon the both the bills that I discussed. So basically, Google itself, in a response to EU's Article 29, accepted that till July 2015, it got 1 million requests for removals of URLs, and around 41% of the same were removed. So basically, as it was also, I was hearing somewhere that Mark Zuckerberg also said that we do need a regulatory framework strongly here, and we can also see it in the fact file also. Also, basically, the IoT or the marketability is increasing exponentially from $2.99 trillion in 2014 to $8.9 trillion by 2020, right? The same thing, the basically four big giants, tech giants, that is Google, Amazon, Facebook, or the Apple, and followed by Microsoft and IBM. They are the main gainers that have gained immensely, right? They are not only gaining by providing us good facilities, obviously, but also by from our this personal data we can suggest. This is what the fact file suggests, right? Facebook again, right? There have been various controversies in past 1 decade also, right? And the overall revenues of about $55 billion, that is a whooping high, I can say, basically has gone in the pockets of Facebook, basically, and based upon this, that basically what is happening for this data protection today, right? Why we are discussing this again. Right? One of the important things that also spearheaded the progress, that is the Google Spain case. Everyone knows here, right? But I would like to skip, as has been discussed by the other authors also, right? So this is the balance of interest now which has to be brought, that is the right to be forgotten and the right to be eraser, right? So if you could provide this, and if even the amendment of 2019 could go ahead with this, so it would be very, very sensitive that we would be able to provide some justice and some consonance, we can say, and some good right in the hands of the data principle, right? So this is where basically we would say that the way is again ahead, right? We have to do much, and this again, this bill has to see the light of the day. These things basically I would like to conclude that yes, it is a very, very basic privacy framework that we want in the country also, and basically thanks to the general data protection bill of the EU, the GDPR, that provided internationally a framework for everyone, right? Because it was not being discussed earlier, as see that in the typically in a country like India, where these things just gain the pace for 1 decade, and moreover, as I suggested, globally in past 2 decades or 2 years, we can say, of pandemic, right? So going ahead, let's see how the things turn out, right? With this, I would like to thank the organizers of the conference, of the General Global University, for inviting me for this talk, and also to all the other speakers for sharing their wonderful ideas. Hope I was able to connect with everyone. Thank you very much.
Thank you very much, Professor Sharma. That was very insightful. You have definitely summarized the salient features of the Indian Data Protection Bill very well for the audiences, as well as focused on the differences between the Indian regime of the right to be forgotten vis-a-vis the European regime. Thank you very much for that. So I would like to say that I'm sure that all of the participants, and including myself, we have any number of questions flowing through our mind that we would like to pose and discuss with all the distinguished guests today. However, we do have a paucity of time in the sense that there is another session planned shortly. So since we have a couple of minutes, I will just would like to ask one question. While we would like to ideally engage all the speakers, but if I may request Professor Taylor to answer a specific question that I had concerning the dial that he had proposed. And this is a very straightforward question, which is, do you see any realistic possibility that within our legal regimes in any one of these jurisdictions, we can, if I may put it so, go full throttle, be able to take it all the way up and realistically so? So that's something that I would like to hear your opinion on.
Very short answer, yes, in some contexts. So an obvious example here is in relation to processing data relating to children, where there is already a best interests kind of requirement in relation to the data processing. So I think there will be some sectors, some contexts where we can go full throttle, as you describe it. But I think in most circumstances, what is likely to be more achievable is that middle ground.
Yeah.
Where, but there's significant work to be done understanding just whose interests it is that are going to be protected.
Thank you very much, Professor Taylor. With that, we come to the end of this session on understanding data privacy framework. I thank all our distinguished guests, Professor Taylor, Professor Marshall, Professor Peterson, and Professor Sharma for sharing their erudite views with the audience. I'm confident that through your words, all of our guests and participants will leave this session with a deeper and a more nuanced understanding of the foundational issues involved in data privacy law. I thank all the guests for their participation and patient listening. With that, I conclude this session. The next session will be on the role and relevance of GDPR, which shall commence shortly. Thank you very much, and please join for the next session.
to the second session of the day-long conference, The Road Ahead in Implementing Personal Data Protection Legislation Effectively, Lessons from EU and Beyond. Once again, I welcome you all, and good morning and good afternoon based on where you are across the planet. Okay. This is the second session of the 3 sessions, and we will be focusing upon the role and relevance of GDPR. The technical session will broadly consider different perspectives connected to operationalizing EU-based GDPR. The session will also focus on effective implementation and the administrative challenges that supervisory authorities may face while fulfilling obligations envisaged upon under GDPR. Now, without taking much time, let me first give a short introduction to all the speakers or the panelists, and then we will go ahead with the discussions. The format of the discussion is going to be with 15 to 20 minutes given to each of the discussant, and then in the end, we will have the larger question and answer round if we have time. So starting in the alphabetical order, Mr. Fabrice Naftalski is one of the first panelists. He is the EY Global Head of Data Protection Laws and Services. We have with us Professor Lucilla Gatt, professor at the University of Naples. We have with us Professor Paolo Balboni, professor at the Maastricht University. We have with us Professor Romeo Kader, professor at University of Utrecht. Now, we will start with Mr. Fabrice Naftalski, who is going to be our first speaker. Mr. Naftalski is the EMEIA Head of IP, IT, and Data Protection Practices. He has been a lawyer for 22 years and is the Europrize legal expert to certify compliance of IT services and products to European directives. He is also the founding partner of ICT Cyber Consulting, a company specialized in information and data security. Now, without waiting much time, I will request Subham to allow Mr. Naftalski to share his screen, and he can go ahead. Over to you. Hello. Yes. Yes, Mr. Naftalski, over to you. You can go ahead with the conversation.
Can you hear me?
Yes, we can hear you.
Okay. So good morning and good afternoon to all of you. I'm very pleased and very honored to be invited by the Jindal Global University, and it's really an honor to speak among so prestigious academics. So it's really my pleasure. By way of introduction, as you just indicated, I am leading globally the EY law data protection practice. EY is acting as a law firm in 90 jurisdictions, and I am based in Paris with a team of 25 attorneys at law specialized on data privacy. And our day-to-day work is to support our clients, which are mostly international corporation or organization, in the development and in the implementation of their data protection compliance program, including performance of data protection compliance audit or support in case of investigations from data protection authorities, because in Europe there are more and more enforcement, more and more investigations or litigations around data protection topics. So I would like first to recall that GDPR is not in the EU a completely new story, because within the EU we had local state member data protection frameworks in the 70s. It was the case in France, in Spain, in Portugal, in Austria. So we had already a set of data protection legal frameworks which were very close to the existing GDPR. And in addition to that, in 1995, the EU Data Protection Directive 95 was enacted. And the main principles, the main fundamental rights, data subject rights, and the main requirements provided by the former Data Protection Directive were very similar to what exists within the GDPR. So the rule of law, I will say, the core principles, the pillars of the principles we know under GDPR are not new within the EU. What is really new, and I think it is the main innovation from GDPR, is the move from privacy in the books to privacy on the ground. And one of the main challenge from the policymakers within the EU was really to make sure that the core requirements, the data subject rights, will be implemented within organizations, because at the time of the entry in force of GDPR, the level of implementation of the rule of law was really limited within the EU. In certain states, you had filing or notification obligations which were performed by companies, but then they were not really focused on really managing the all core principles around security, confidentiality, data retention limitation, framing of transfers outside the EU. So the main objective was really to make organizations accountable toward the data subject. And so the main innovation of GDPR is the move toward operationalization, which is based on some principles as the accountability principles, which means that organization need to document the way they monitor, the way they manage their data protection compliance, and to achieve this goal, the GDPR has provided many mandatory requirements, such as the obligation to develop a register of data processing, meaning to list off set of data. When I said data mapping, you know that the main principle of EU data protection law is the binding purpose limitation. Each time you collect or process personal data, it is always for a specific purpose. And so what we call the register of data processing is based of purposes of data processing. So you have to list all purposes of data processing, and for each of them, you have to specify the categories of data which is collected, the legal basis of the data processing, the recipients of such personal data, external or internal within your organization, the mechanism in place to frame transfers outside the EU, the confidentiality and security in place. So you have many information which need to be listed in order to demonstrate that the company has a good knowledge of the data processing in place. Another key component of accountability or operationalizations is the data protection impact assessment, meaning that each time an organization will develop a new data processing to the extent this new data processing can present a certain level of risk, the organization has the obligation to perform an assessment of the level of risk in order to develop implement additional measures to limit the risk for data subjects. So, for instance, when data processing will involve sensitive data, as health data or as criminal data, or when the data processing will be based on very innovative technology like blockchain, like Internet of Things, for instance, the organization will have to perform this assessment before starting the implementation or the development of the solution. Another important point is the obligation in many organizations to appoint a data protection officer. It is compulsory in the public sector, but it is also compulsory for companies dealing with a high scale of personal data and specifically sensitive data. So, for instance, healthcare industry, pharma companies, banking industry are subject to the obligation to appoint a data protection officer who is in charge of monitoring compliance with GDPR and local legislation within the EU state members. Another key principle for operationalization are the privacy by default and privacy by design principles, which oblige our organization to investigate about the compliance of new solutions at the very beginning of a project in order to limit the risk for data subjects. And there are new tools like certification. So we expect the first certification mechanism to be recognized within the next months with the Euro Privacy initiative, which has been presented by the Luxembourg Supervisory Authority. So all these steps have permitted to companies to develop the effective implementation of the rule of law within all types of organization. Another important point, maybe also important in terms of effectiveness, is that the enforcement has been facilitated with very high level of fines in case of non-compliance with GDPR. You know that according to GDPR, sanctions or fines can reach 4% of the annual turnover of a group, which is a lot. So it can be considered that GDPR is a success story within the EU. Data subject rights are more and more aware of their rights. They are exercising their rights of information, the rights of access, the right of being forgotten. We see that the data protection officer are spending more and more time to manage and to respond to data subject rights. Data subject rights also complain more and more often to supervisory authority. It's very easy. You have to go on the website of the supervisory authority and you can register your complaints. We also observe more and more class actions against companies which are not complying with GDPR. The last important sanction was taken also in Luxembourg against Amazon in connection with the lack of legitimate legal basis for the internet-related data processing. So we see success on the data subject side. We see success on the side of companies which have invested a lot in data protection compliance. And another very important sign of success is the development of data protection within environmental, social, and corporate governance initiatives. More and more investment funds are not checking compliance with GDPR before investing in organization. So in the interest of time, I will move to the GDPR success story beyond the EU. What we also observe is that more and more countries have their data protection legislation. According to United Nations last year figures, the 128 jurisdictions had already data protection frameworks, and I think it was 12% were preparing their frameworks. We see new data protection legislation emerging everywhere. We had recently a project in Middle East, and we have seen that in Dubai, International Dubai Financial Center, in Abu Dhabi Global Market, there are new data protection frameworks which are very similar to GDPR. In Egypt, you have new framework. In Qatar, new framework. In China, next November, you will have a very similar data protection framework, which reflects a lot the main requirements of GDPR. So the international success story of GDPR is that GDPR is becoming the international standard, and you will very observe that most international, most new data protection legislation within the globe is really taken in consideration some key points of the GDPR. So there is a GDPR success story beyond the remit of the EU, which is a good news for international organization and for multinationals, because it facilitates the emergence of new standards and of interoperability. Having said that GDPR has still important challenges. One of the objectives of GDPR was to limit the fragmentation within the EU between state members' data protection legislation. As you know, within the GDPR, there are 54 open clauses, meaning that state members can be more demanding than GDPR on certain topics, such as management of sensitive data or criteria to appoint a DPO. Or if you take the age for minors, it's not the same age which is taken in consideration in France or in Germany. So there are still a lot of fragmentation, even if 80% of the rules are the same. Another challenge is about mechanism to transfer data outside the EU, since Schrems II ruling from the European Court of Justice, there are additional layers to be implemented by EU organization to transfer data outside the EU, and it's very challenging because in addition to the mechanism provided by GDPR, you need to perform transfer impact assessments. So that's really a challenge for EU groups or any organization exporting data from the EU. And maybe the last important challenge for the EU is also to adapt GDPR rules to innovation. It's not so easy to implement GDPR rules when you speak about blockchain, for instance, for the data retention requirements, which imply to limit the duration, the storage of personal data. Or when you speak about algorithm, artificial intelligence, it can be also very challenging to implement GDPR. So a lot is expected from co-regulation, from discussion between supervisory authorities, between the European Data Protection Board, the EU Commission, and IT companies or stakeholders of innovation to find the right balance. One strength is that because the GDPR is based on principles, you have some flexibility. There is no within GDPR a specific rules applicable for facial recognition, for instance. Facial recognition is addressed as other types of technologies. The fact that GDPR is technology neutral is an asset, but it's not so easy to manage this implementation of data subject rights or other rules from GDPR within new technologies. So that's the points I wanted to share with you, and I am happy to debate with the other distinguished panelists and to respond to any questions the audience may have. Thanks a lot.
Thanks a lot, Mr. Naftalski, for such an insightful discussion about the need for coordination among the different organizations and the success stories for the GDPR, not just within EU, but even outside the boundaries of EU. For the paucity of time, we will be taking all the questions by the end, so we will have some time for the discussion. Meanwhile, I would like to tell our panelists that we are also live on YouTube. So we will be receiving questions from audience from that side also. So we will be talking about them in the end. So I will now invite our next guest speaker, Professor Lucilla Gart. She is a professor at University of Naples in the area of civil law, family, new technology law. She has also been professor of private law and private comparative law. She is the current...
Sorry, colleagues. Can I speak as last one, please?
Okay, it's not a problem.
Okay.
We will take you in there.
Thank you so much.
Okay, not a problem. So let me then invite Professor Paolo Balboni. Professor Balboni is a professor of privacy, cybersecurity, and IT contract law at the European Center of Privacy and Cybersecurity within the Maastricht University Faculty of Law. He is a top-tier European ICT, privacy, and cybersecurity lawyer and serves as a data protection officer for multinational companies. He is a member of the EU MedSat Data Protection Supervisory Authority, and he is also the founding partner of ICT Cyber Consulting, a company specialized in information and data security. Professor Balboni is also the co-chair of Cloud Security Alliance Privacy Legal Agreement. Without further delay, I will request Professor Balboni to go ahead with his discussion. And over to you, Professor Balboni. You are on mute, Professor.
Thank you very much. Can you please confirm that you can see my screen?
Yes, we can see your screen, Professor.
Okay, perfect. All right, so to some extent, my presentation will build on the precedent presentation of Mr. Naftalski. The idea is to share with you some reflections on data protection return on investment, and also the GDPR effect on global privacy. So the GDPR, in a nutshell, brought few key elements into the European privacy scenario and is influencing the global privacy scenario. Well, first and foremost, with the principle of accountability, which is shared in multiple legislations around the world, which in a nutshell is about not just doing compliance, but also making sure that you always collect evidence of compliance and you can share upon request of the supervisory authority. Second point, it introduced the so-called risk-based privacy, so not one size fits all but a risk assessment, a risk on the rights and freedoms of individuals, not the risk on business continuity or the pure security risk, needs to be carried out on all data processing activities carried out by an organization. And then it crystallized the concept of data protection by design that was not invented in Europe, but was invented more than 10 years ago in Canada by Dr. Kavukian, and the concept of privacy by design. And it's actually where I see privacy going more and more. So in order to make sure that this data-driven economy and the digitalization of all the processes is gonna meet the privacy requirements and security requirements. So the development of the concept of data protection and data security by design is gonna be very central in the global discussion. It is already now and more in the future. And last but not least, the centrality of data subjects and their rights, which is, of course, lies at the core of European privacy, but I would say more and more, of course, at the global privacy level. So let's start in a very practical way, and by leveraging a service that we provide our clients with our law firm. It's called Privacy Sanction Radar. So we mapped all the decisions of the European Supervisory Authority, and actually we go beyond Europe, also outside the European Union. Then we make all sorts of statistics and analysis for our clients. And, you know, through this very, very useful tool, we can identify the typical cause of sanctions so far. So after the analysis of 800 plus administrative sanctions, we can establish that the vast majority of sanctions has been issued by supervisory authority for violation of Article 5 and Article 6. But this is not really quite the message I want to bring to you, because Article 5 and Article 6 are actually containers of obligations. In fact, Article 5 is about listing all the privacy principle, Article 6, all the legal basis. So, you know, of course, they are there multiple times when sanctions are issued. But where I want to drag your attention is looking at single obligations and the typical cause of sanctions when we look at single obligation. Then we need to go to Article 32, which is about having in place adequate security measures. So we can say from our statistics that the most frequent single violation that was sanctioned in the European Union was violation of Article 32. So the message is it's very important to secure your data, put in place adequate security measures. And the vast majority of the sanctions issued according to Article 32 actually started with a data breach. The notification of it to the authority, then the authority started an investigation, and during the investigation, they established that there were not adequate security measures in order to prevent the data breach. So securing data and correctly manage data breaches is definitely where to start when you want to create a robust and effective data protection compliance framework, not just in Europe, but at the global level. The second single cause of action is violation of Article 13, which is about transparency, together with Article 12 and 14, is, you know, regulating how an organization should share information related to the data processing activities with data subjects. So the second point I want to make, be very careful and very focused on complying with transparency to make sure that you have information notice, privacy notice, cookie policies available online, easy to understand as it is indicated in Article 12 of the GDPR, and with all the necessary elements as per Article 13 and 14. And then, of course, last but not least, also very much attention with respect to sanctions to violation of data subject rights Article 15 to Article 21. So what I'm saying is also reflected in the top 10 highest sanctions so far issued by the supervisory authority. If we look at the top three, so the one against Amazon by the Luxembourgish Data Protection Authority, the Irish Commissioner against WhatsApp, and the French Commissioner, so the CNIL, the French Data Protection Authority against Google, all the top three are actually very much focused on violation of transparency and correct legal basis, meaning specifically the use of consent. When we go on in the top 10, we start to see more and more than the identification of Article 32, violation of adequate security measures in the decision of the Italian Data Protection Authority against the telco team Telecom Italia Mobile, but also the very famous data breach happened to British Airways, and the other one happened to the Marriott International. They got a sanction eventually on Article 32 of the GDPR, not Article 33 or 34. And then we go progressively down, and we see also, again, the Italian Data Protection Authority against one telco, Vodafone, and a provider of utilities, energy, any gas and luce, again, very much focused on data security. So on the basis of what we just discussed, let's have a look at the return on investment with respect to privacy. There is an interesting and recent Cisco study that actually states that for every dollar spent on privacy in 2020, the average organization gains $2.7 in associated benefit. And those benefits are typically in terms of making the organization more robust, so less prone, less exposed to sanctions and data breaches that may also result in reputational damages, but also the fact that the more you work on streamline your processing activities and making them compliant with concepts like data protection and data security by design, the better your organization can work. And also, the more attractive is your organization, as it was mentioned also before, for potential investments by equity funds or for potential companies that would like to buy your company and or simply doing business with your company. So here I want to share with you the 6 steps that we have identified in order to put in place a robust data protection compliance framework. These are very much based on GDPR, but as we advise with our law firm, global companies, we have experienced the benefit of structuring a global data protection compliance on GDPR and then just acting into, carrying out localizations to the strictly necessary in other countries outside the European Union. Whatever I'm saying is also published in a paper, over 100 pages paper that I published together with colleagues on the Indian Journal of Law and Technology. So it is available online. Step number 1, think about accountability as the first step, not just doing compliance, but also being able to provide evidence of compliance. For example, when you are logging consent in a digital property, being a mobile application or a website, you not only need to think about having an information notice available, collecting consent of the individuals, the user, but also recording the logs in an unmodifiable way. And those logs need to have the timestamp. They need to have information about the information notice that was published when the consent was provided. You need to reconcile that log with the single individual by way of a unique identifier. And everything should be stored in an unmodifiable way. Then, taking into consideration the concept of data protection by design, you need to put in place data processing activities that are in line with the principle as set forth in Article 5 of the GDPR: finality, proportionality, minimization, lawfulness, data retention, data security, and so on and so forth. So don't think about data protection by design as a principle, but as a mean to fulfill the principles set forth in Article 5. And then you are ready to act in order doing the risk assessment on all data processing. And when the risk is high, you need to carry out a full-fledged data protection impact assessment. When you have walked those three steps, you need to have the situation under control because you have mapped everything. You have analyzed the key elements of the data processing and you have assessed the risk. And then you're ready then to start securing the data processing, writing transparent information notice, indicating the correct legal basis being consent, legitimate interest, performance of a contract, or compliance with the legislation, and so on and so forth. And last but not least, make sure that you can reply to data subject rights request within 1 month's time, which is the traditional time. Maximum extent is for 3 months. When you are done with it, do it all over again because we follow the principle of Deming of ISO 27001 of continuous improvement. So it's always very good to think about your compliance framework as lively organism, a lively effort that needs to be adjusted over time and recurrently audited. So in the slides to come, you will see a deep dive in each and every single step. I will just leave it to you with my slides. And I will now touch the very last point about data protection as a corporate social responsibility. Well, actually, this is a research project that I'm leading at Maastricht University and specifically the European Center on Privacy and Cybersecurity. I devised this concept in my inaugural lectures a few years ago, and now we are finishing the first data protection as a corporate social responsibility framework that is going to be ready and available by December this year, together with that we have devised together with a number of stakeholders, including also data protection authorities, stakeholders like the CNIL, for example, the French Data Protection Authority, but also ICO, the UK Data Protection Authority, the Dutch Data Protection Authority, and so on and so forth. So the very important point, as it was reflected also by the speaker before me, is that ESG, so the entire movement of environmental, social, and corporate governance is growing massively. There is a massive attention, not just by investment funds and business partners, but also consumers. Consumers are caring about environment. They are caring about companies that are socially responsible, and they are choosing for it. Here are some statistics that you can read whenever you have time on my slides. But what I wanted to actually show you is our framework. So our framework, which is going to be expanded by December. So here you see 5 principles, and you see 3 rules per principle, where we're going to end up having 5 rules per principle. But this is already where we are, and we have also published some preliminary research on that. Rule number 1, embed data protection and security in the design of the process, implementing, for example, data security by design. So we talked about data security by design already a few years ago, and I'm very happy that now even the Biden administration have recently stated that data security by design is a matter of corporate social responsibility. In this first principle, we also develop the control of fairness by design, which is very important when you talk about algorithm and artificial intelligence. Second principle, be transparent with citizens about the collection of their data. Under this principle, we have developed a full-fledged of icons to signal risky data processing activities. You're going to see them in a minute. Third point, balance profit with the actual benefit for citizens, carrying out the so-called PMB test, the profitable and beneficial test, engaging stakeholders to understand what they care, what they look for, taking that into consideration and reflect it in your data processing activities. Fourth, publish relevant findings based on statistical anonymized data to improve society. So organization sharing with the consumer, with business, with governments, in a way that is respectful for the privacy and data protection, but also very useful in order to share knowledge and best practice and improve the digital economy and the digital society as a whole. last but not least, devote a portion of revenues to awareness campaign for citizens with regards to the data-centric economy. So not giving money back to the citizens, but making sure that they will steadily and increasingly understand their rights and how to protect themselves in this data-centric society. At the end of our efforts, so at the end of this year, we're going to have an auditable framework on data protection as corporate social responsibility. Here are the icons that we are testing in a very large survey, and they're going to be slightly modified towards the end of the project, but just to give you an idea, so icons on marketing, fully automated processing, transfer, data sharing, sensitive data. There are more icons to come. We're going to end up with 9 or 10 icons in this respect. So with this, I want to thank you very much for your attention, and I look forward to the discussion with the other speakers. Thank you very much.
Thanks a lot, Professor Banu. Such an insightful presentation, and we will be really interested in the idea of data protection as a corporate social responsibility. Without wasting time, I will request our next speaker, Professor Romoe Kadir, to present his work. Professor Kadir is currently a professor at University of Utrecht. Professor Kadir is also the president of European Institute of Privacy, Audit Compliance and Certification. He was the first appointed data protection officer ever in the Netherlands, and he's a seasoned European privacy and data protection expert with 20+ years of practical experience in EU privacy and data protection law, business management, compliance, and ethics. Now, I will request Professor Kadir to share his screen and go ahead with the presentation. Over to you, Professor Kadir.
Thank you very much, Professor Kumar, for this kind introduction. Is my screen visible?
Yes, Professor Kadir, your screen is visible. We can see the screen.
Excellent. Thank you very much. Thanks to the organization. Thanks for having me. Congrats to our distinguished Jean Monnet Chair, Professor Inaugural Gupta. It's a pleasure to be here and sharing some thoughts, insights from a more data protection professionals perspective from within the EU. Now, the technical session of today is about the role and relevance of general data protection regulation. I've been asked to focus on 2 aspects of this: the need for re-engineering business models to comply with the GDPR, and some administrative challenges likely to emerge in implementing GDPR from a supervisory perspective. Now, just to clarify, I will be talking from a practical perspective. So, I'm involved in a few initiatives, which I will also refer to as a president of the European Data Protection Professionals Association. I'm also involved with the development of privacy management software. I'm a member of the International Board of Experts of Euro Privacy Certification Scheme, and I'm president of the Council of Ambassadors of the Indian Association of Data Protection Professionals, a very nascent and interesting professional organization. Now, I would like to speak about the following: role and relevance of GDPR, a few general observations to make. Now, basically, what do we need for effective implementation, right? So, and these are very key core basic questions. Then, what does this mean for business models? Re-engineering or not? Which administrative challenges are we talking about? And of course, some lessons to be learned for nascent data protection jurisdictions such as India. So, first of all, let's be quite clear that the ultimate GDPR narrative has interesting international dimensions. Protection of fundamental rights and freedoms of natural persons is at the core of the GDPR purpose, right? This has been reiterated many times, many occasions, many documents, Schrems to French Conseil d'État, and many more. Second, the GDPR serves as a kind of reference point for global data protection standards. Many countries, many states, it has been said before, are having a close look at the GDPR formula. GDPR is based on universally applicable principles. Over 60 jurisdictions around the world have proposed or are drafting postmodern privacy and data protection laws, and are inspired by, of course, also the principles as codified in the GDPR. It's also a interesting framework for promoting self-regulation and certification. The GDPR, as a technology-neutral law, endorses self-regulatory instruments such as certifications and technical standards. The GDPR provides for an accountability mechanism. It has been said many times before by my distinguished previous speakers. So basically, it allows natural persons and legal entities to demonstrate compliance with GDPR obligations. Now, please have a closer look at the term demonstrate. Demonstrate doesn't only mean you have to prove it, you also have to explain why you have done it the way you have done it by using reasonable arguments. So of course, we are all looking forward to the 2024 full evaluation report of the GDPR. I will discuss some intermediate findings later during my presentation. The GDPR is a major business driver for fulfilling data subjects access rights, as has been put forward by this interesting research. And the second driver is the organization's reputation. Interestingly enough, this is also what counts from a business perspective. This is an interesting find. What do we need for effective implementation? Actually, this is part of ongoing research with the Research and Innovation Center of the European Data Protection Professionals Association. So we are researching the single point of implementation clarity. This is what we need from a data protection professional's perspective, right? What are we supposed to do? How are we supposed to act on whatever legal obligation, on whatever security obligation, compliance obligation, and so on. So the first optimum seems to be the legislative clarity we need. Why? Not only because of legal actions and legal liabilities, but also because of the public trust argument. Second part of the optimum is clarity provided by supervisory authorities. Clarifications and clear guidelines is what we need from supervisory authorities. Consistency of enforcement actions and a framework of ethics. And of course, as distinguished Professor Balboni just now explained to us, the importance of ESG, especially the S side of ESG, the social side of it, which is related to human rights, which is at the core of GDPR. But also, of course, ethics from a market interactions perspective. Strong stakeholders engagements, active operational engagement for multidisciplinary stakeholders. Which disciplines did the European Commission state right from the start of the GDPR? It was mentioned that at least compliance, legal ethics, and security should be part of any multidisciplinary stakeholders event. And also, of course, we need to be aware of the specific societal roles to play by human rights organizations, civil rights organizations, and so on. Now, a next optimum would be best practices induced operational practices. Now, operational excellence can be induced not only by having clear legislations, but also by self-regulatory vertical industry-based collaborations. Now, this is a growing insight in the European reviews of the GDPR that the verticals do play an important role for the ultimate success of GDPR operational compliance. And also, we need operational practices for M&A practices, due diligence, and so on. So another interesting find of our research is that certifications of full information life cycles is what we need at all levels. So this information life cycle from notice till disposal of info needs to be covered by certification. So not only from a process perspective, product perspective, service perspective, but also from a people's perspective and technology perspective. So these kind of perspectives do contribute to the ultimate success clarity for certification schemes and certification requirements we need as data protection professionals in order to be successful. And the sixth element of the optimum for implementation clarity is continuous compliance monitoring and timely intermediations if needed. Now, monitoring is not a one-time off exercise, right? But needs a solid, concerted, permanent effort of keeping guard of the data protection rationales, especially in the light of the ever-advancing technologies. So, and in case needed, timely intermediations mechanisms are key for us as data protection professionals to be successful in our roles and responsibilities. Now, as far as the engineering side of things, privacy, legal compliance, engineering technologies do play, and it has been said many times by the previous distinguished speakers. The developments of digital personal data protection has an elementary impact on how economic values and related business models are created. That's obvious. Ensuring that all personal data processed is brought in scope and under control is difficult and expensive without technology. So this is where the use of AI-powered applications comes very useful in reducing administrative burdens and manual workloads for many companies altogether. Now, at the forefront of a positive privacy user experience is the ability of an organization to promptly handle data subject rights. For example, right, like the other 200 and plus legal obligations we can infer from the GDPR. So DSRs are just one category of obligations. DSR cover a defined set of rights where individuals have the power to make requests. This has been discussed already. So from an artificial intelligence impact assessment perspective, this is a find of a platform back in the Netherlands, right? So basically it starts with defining the purpose, specific purpose of any AI application, then immediately assess the ethical and legally justified use before the interaction starts between reliability concerns and ethical, legitimate purpose, accurate, and so on. And it all ends with the accountability about choices. Now, please be aware that in principle, this is operational privacy by design in AI contexts. Just an example of how we would like to see, as data protection professionals, clarity on how to do these kinds of analysis and which factors to include. Now, this is just an example of EU co-funded privacy technologies, interesting business process re-engineering and functional toolkit for GDPR compliance. I believe my previous speaker is much more involved in this initiative. So basically, a privacy by design process lifecycle based on a broad spectrum of following three innovations are discussed. Process analysis and redesign, such as automatic verification of processes, the compliance toolkit encompassing sophisticated functionalities, and the use of process mining for process discovery, process monitoring and controlling purposes, and so on. these kind of toolkits, these kind of advancements are very helpful for data protection professionals to perform their tasks at the end of the day. Now, from a business model perspective, um, sure, from back to the 60s till now, enormous shifts in business models, and we're heading towards privacy technology solutions as a service. Privacy manager is just one of the examples which I'm involved with. So what does this mean? Business, the GDPR as far as business models are concerned. Now, this is an interesting breakdown of several business processes. So at level one, performance, training, and learning should be taken care of as per the GDPR. Project management should be taken care of. Incident management, data quality, continuity management, and so on. This is nothing new. So this is the operational result of solid court cases such as Schrems 1, which already has been discussed. Also, accountability has been discussed and privacy measures altogether. So, just to mention a few strategic, administrative challenges for supervisory authorities, given the limited time available. So the European Commission already stated that sufficient human, financial, and technical resources for supervisory authorities are key and should be taken care of. Also, safeguarding independence is a challenge. Conflicts of interest management is a challenge, especially where the supervisory authority would like to act as an advisory mechanism, but actually is limited by law to do so. Managing differences of opinion while preserving EU consistency is a challenge because of national differences. Complaints handling of data subjects in a satisfactory and timely manner is still a challenge for many DPAs. Understanding business compliance operational challenges. Many DPAs still lack essential knowledge of how the operations is being done in practice. Resolving conflicting international data privacy rules. Now, a lot of work is being done in this respect. International enforcement conciliations is something which will be of much more importance in the near future. Collaboration with data protection professionals at large, and especially with DPOs, should be far more um, uh, specific and far more collaborative by nature as until now. Keeping abreast of technology challenges is also a challenge for the DPAs. So this is a breakdown of a work plan for a data protection officer, as I published the beginning of this year in my latest edition. And what is a challenge for DPAs is the simple legal GDPR legal codification of the mandatory cooperation between DPAs and data protection officers. Now, this is a source from the European Commission monitoring necessary actions. So these actions are being taken, will be taken in the near future, implementing and complementing legal framework, making new governance systems deliver its full potential, supporting stakeholders, encouraging innovation, further developing toolkits, promoting convergence and developing international cooperation. To finalize my findings of today, which lessons can we learn? Clarity is key for success. Multi-stakeholders engagements, concerted industry vertical best practices, certification schemes at all levels of operation. One single point of clarity is key for success. For effective GDPR or data protection implementation, one single point of clarity is needed for data protection professionals to perform their respective responsibilities and tasks, right? As identified and discussed just now. Another lesson to be learned is that concerted multi-stakeholders engagements can assist actually supervisory authorities in identifying the challenges ahead. It can also provide supervisory authorities with advice to achieve an appropriate level of awareness. It can also provide with advice and expertise in relation to the preparation of delegated acts and where appropriate and necessary, the early preparation of implementing acts. So a very important operational contribution to be made. Convergent verticals, best practices. Now we um, came to the conclusion that these verticals can contribute to study and analyze the impacts of a catalog of legal instruments and their national implementations on the fundamental rights of individuals, which is at the core of Article 1.2, the purpose of the GDPR. So the last lesson I would like to share with you is that we need certification schemes at all levels of operations, meaning clear certification requirements for processes, products, services, people, and technologies. As we all know, the GDPR does not cover certifications of people. It refers to ISO 17065, covering products, services, and processes. So the people parts is to be done by self-regulatory organizations. To end my contribution, just a quote from our late European Data Protection Supervisor. We do not need to reinvent data protection or data protection principles, but we need innovative thinking in the field. Thank you very much. Thanks all.
Thanks.
Chair.
Thanks a lot, Professor Kadir, for such an informative presentation. I think a lot of us will just go through the video to see the slides again, that what you have talked about. Okay.
I hope so. They are available if people want to have them.
Yeah. So now we will go to our next panelist, Professor Lucilla Gatt. Professor Lucilla Gatt is the professor of Civil Law, Family, New Technology Law at the University of Naples, where she was also the professor of Private Law and Private Comparative Law. She is the current chairholder of the John Monnet Chair Protect, or European Protection Law of Individuals in relation to New Technologies at the University of Naples, and was the John Monnet Professor of European Contract Law at the University of Campania between 2005 and 2009. Professor Gatt, we welcome you to the panel discussion. Over to you, Professor Gatt.
Yes, just a moment, because I have some problems to see you. Just a moment, please.
We can see your slides, Professor.
Yes, you see them?
Yeah, we can see your slides. Yes, they are visible to us.
So, just a moment, please, because I don't see anything. I don't know why, but okay. Allora, just a moment, please. Ecco. Okay. So, do you see my slides?
Yeah, we can see your slides, Professor.
Of course. Thanks so much. Okay. Just a flash, because the time is really short and it's really few time, but I would like just put on the table a problem, a question to which I don't have an answer, if I have to be honest. So just a little flash to say that GDPR in Europe is a very important statute, a very important regulation, and in Europe, obviously, we are proud of this statute, but we can't deny that it has a lot of defects, I could say, but one of these is the problem of so-called emotional data. Emotional data, probably everybody can think that are the same that personal data, but probably this is not true. Anyway, can go on, and the three important points that I would like to expose and treat in this paper is the concept and the definition of affective computing in relation to human emotions, the definition of emotional data, and the possible relationship between emotional data and general data protection regulation. It's difficult to focus that machine at the moment are available to read our emotions, and they can this activity every day, continuously, and everywhere. What I mean with the word emotion, there are no an agreement about this definition, but with the term emotion, we mean generally 6 most commonly used emotion categories in emotion research: anger, disgust, fear, happiness, sadness, and surprise. The so-called affective computing, recently called emotional AI, is a subfield of artificial intelligence, of AI, a subfield which has particular characteristics. As I tried to explain in this slide, I get the definition that we can find everywhere online, but it's almost right. So I selected affective computing is the study and development of systems and devices that can recognize, interpret, process, and simulate human affects. It is an interdisciplinary field spanning computer science, psychology, cognitive science. The first that has focused this field is the Rosalind Picard with the paper in 1995, and most of all with a book, Affective Computing, published in 1997 by MIT Press. This subfield of AI get the machines available to read our emotion, to read and to collect, to detect our emotion. And we can, in considering that SE is bound to be implemented or already utilized in various fields, including recruiting, virtual assistants, advertising, and cards, by making emotion machine readable, AC develops automatically process a new type of data, emotional data. And recently, young research of Leiden University, Andreas Oiselman, has written a very interesting paper about this subject called Fit for Purposes, Affective Computing Meets EU Data Protection Law. And he is focused a lot of important elements about this subject. So the problem, what is the problem? What I would like to say that big data is a composite really in which different types of personal data converge. Among these data, so-called emotional efferents relating to the sentimental and affective sphere of the human beings, younger or older, and are currently almost completely invisible to the national and the European legislator. The GDPR ignores the emotional data, and in no mandatory regulatory act, it is possible to find even a vague reference to them. In fact, I would like to show to show you that probably in so-called Artificial Intelligence Act, European Artificial Intelligence Act of April 2021, we can find a lot of reference to this concept, but in GDPR, we can't find anything about emotional data. As I have already said, there is a field of research in the higher sense robotics and mechanotronics called lovotics that develops devices capable of producing emotion and emotional data on whose treatment or protection no one questions. Abusive cases are easily achievable without incurring any penalty. It's the time to dwell on the problem. So the problem is that, and if we consider that a very strong line of talk on international level that provides for the possibility of making legal the marriage between human beings and anthropomorphic robots capable of empathically interacting with human beings, we can understand the broad dimension of this phenomenon. So we can go on, and I also would like to underline the natural and legal persons who sustain this way of thinking. They are important academics and important businessmen in the world, as you have. As you can read, they have published a lot of books, papers, and they have made a lot of things, like, for example, creating anthropomorphic robot who can interact with human beings from an empathically perspective. So the line of this talk is very, very broad and large. So the question is, how this new category of data fits in the context of the GDPR. And the problem from a juridical point of view is to understand if emotional data are personal data, and in this sense they are subject to the GDPR. Recital 26 and Article 4.1 explain and fix the concept of the identification and the principles of data protection should apply to any information concerning, sorry for the, concerning and identified or identifiable natural person. So the problem is the concept of identifiable. Because in a lot of cases, this machine that can read our emotion, and please, I would like to underline that they are a lot. Our phone, our mobile phone, Cortana, the software Cortana, Siri, and Alexa, and something like that. I don't know if someone has seen the film Jaxi in 2 years ago in the cinema. Very interesting because represents the possibility to realize software with an enormous ability to interact with the human beings from an emotional point of view. So it's very fun, a comedy film, but not so far to the reality. So the problem and the question is if emotional data are personal data, and the consequence of this definition is the inclusion of emotional data in the GDPR. So at the moment, I would like to underline that in a lot of cases, the question is that not the means to identify the individuals concerned, because only anonymous metadata will be stored. In other words, when we have a machine that can read our emotion, the controller says that this machine it's not available to store the data, the emotional data, and but only other data. And in this way, the aim is not to include the emotional data in the concept of personal data. And so on, realizing the goal to exclude emotional data from the regulation of GDPR. So this is a very critical point, and I would like to show that partially there is a trying to include in our statute the concept of emotional data. For example, in this act, you can. I hope that you can see the text. Please confirm me. Someone can hear?
Yeah, we can hear you, Professor.
Yes, of course. Sorry. This is the regulation of the European Parliament and the Council about artificial intelligence, named Artificial Intelligence Act. And if you can see that in this text, if you write the word emotion, you can try 10, yes, you can see 10, just a moment. Yes, you can see 10 results. And if you can, as you can read, in this text, the problem is considered in the sense that our European legislator has focused that there are machines available to detect emotion, human emotion, but European legislator has decided to limit his focus on a single field. In particular, it refers to the field in which it is possible that machine takes decision on the basis of emotional data. So it is a field, is an important field, but it's not the only field. The concept of emotional data is going up. On the contrary, unfortunately, in our GDPR, yes, you can see, just a moment. I try to, yes, ecco, this is our GDPR, and in our GDPR, unfortunately, we can't find anything about emotional data. About emotional data on the assumption that there aren't personal data. If I try, and I would like to show you directly this possibility, if I try to find the word emotion or emotional, I don't find anything. Zero result, as you can see, zero result here. So I would like to stimulate the young researcher to focus this problem and to direct their research in this direction. Thank you so much indeed.
Thanks a lot, Professor, for bringing in the dimension of emotions as part of the discussion with the GDPR through the emotional data perspective. Now we are open to discussion. We have some 15 minutes left in the session. I will start with a general question, which is to all the panelists. The question is, what are the initial trends coming out of the review of GDPR, and whether GDPR is meeting its objective? So we have seen in the first half of the presentations, we have seen that a lot of discussion has been about the implementation. So we'd like to ask the panelists that what are their initial trends, and what their reviews say, that how many objectives or what kind of objectives have been fulfilled and what needs to be done. Any of the panelists can reply to this.
Yes, maybe I can start. As you know, there is every 4 years an assessment which needs to be performed on implementation of GDPR. The first assessment was done in 2020 by EU Commission, and the EU Commission has considered that the level of implementation was satisfactory in terms of dissemination of data subject rights, but that there were still some room for improvement, and one weakness is still the fragmentation, the fact that data protection authorities have not enough resources to match with their roadmap. You know, data protection authorities have a lot of tasks in terms of enforcement, in terms of co-regulation, in terms of cooperation. And in certain countries, they have very limited resources. So that's one obstacle to the seamless implementation of GDPR. Maybe GDPR is still a bit too demanding for small companies or middle-sized companies. So there is a strong recommendation from EU Commission that EDPB and data protection authorities will provide more operational guidance to middle-sized and small organizations, so that GDPR can be implemented in a satisfactory manner within a big organization. Then maybe the last challenge is that the citizens take control of their data, which is not so easy, and which is also based on better awareness within the EU. But that's my first observations, and I am sure my other distinguished colleagues have other comments.
Thanks a lot, Professor, for answering the question. We have another question. It is also open to any of the panelists. Okay? The question is, what are the lessons to be learned prior to transfer of data after the fall of privacy shield? So they want to ask that, what are the lessons we can learn prior to transfer of the data after the fall of the privacy shield?
Sorry, just as a joke, how much time do you have to answer that question? Because we could stay here maybe for one day discussing the implication of the SHREM 2 and the fall of the privacy shield. But I think, in a nutshell, there is a theoretical regime that makes a lot of sense, whereby supervisory authorities in Europe are requesting to do a systematic transfer impact assessment and to potentially put in place supplementary security measures to the data transfer. And in theory, it makes perfect sense. In practice, it's almost impossible, in the sense that even when you deal with multinational companies that have a lot of resources, thinking about carrying out the transfer impact assessment systematically on every data processing which entails the transferring of personal data outside the European Economic Area to countries that did not receive an adequacy decision, it's almost impossible, in the sense that you need to put together enough skilled professionals. So first and foremost, European lawyers cannot perform alone a transfer impact assessment, because you always need to liaise with professionals that are qualified in the recipient country. And then, even if you do the transfer impact assessment, and this will signal that there are conflicting legislations, then you need to evaluate which are supplementary measures that can be fit for the purpose of mitigating the risk of interference of law enforcement agency of the foreign country. And even if you find them, and of course, like the usual suspects are encryption, pseudonymization with the keys in Europe or by trusted third parties in Europe, then the point is, would the service still work with encrypted data? And usually the answer is not really, if you think about especially software as a service provisions that whereby the important needs to see the personal data in clear and not encrypted. So on the one side, it all makes sense. On the other side, it doesn't work.
Thanks a lot, Professor Baloni, for that nice answer. There is one more question, one last question, which is more about what you have already discussed about it's impossible in a way and for across geography. And the second is that you talked about data protection as a corporate social responsibility. So the next question is more a lot of what we are talking about is from the European GDPR perspective, but a lot of services or a lot of manufacturing has shifted to other parts of the world. And there, these GDPR as a regulation or similar regulations are yet to evolve, because most of the time for these supply chains, the idea is to reduce cost. In such a scenario, how do we look it from the perspective of data protection to be provided as a corporate social responsibility?
Or if you want, maybe just 2 words in the sense that so I think when you inject the dimension of corporate social responsibility, you need to find a business reason to do that. If not, it remains, again, a very nice word, but they're not really operationalized. So, for example, in our research project, we have spent a lot of time in understanding what is the business case for a multinational to embrace data protection as a corporate social responsibility, because if they don't embrace it, it's not going to work. So I think it's all revolves in this, return on investment on privacy and data security, and that I also touched upon in my presentation. And I think we're making a very strong case. The financial world is evolving around ESG and corporate social responsibility, and the digital domain. It means also data security and data privacy as corporate social responsibility. And also the consumer environment is evolving and getting more and more attent to responsible use of personal data. So the ecosystem is maturing. I think we're making a good business case. And I think it's inevitable if you want to stay competitive for the next 10 years to strive, to raise the bar. And this is the next level of competition.
Thanks a lot, Professor. There is one last question by one of the audiences that what are the overlaps, if any, between the draft AI regulation and the GDPR? So if any of you can highlight about the overlaps between the AI regulation and the GDPR.
Maybe I can start. It's a bit premature to respond because the AI regulation is not adopted yet. It's still a draft from EU Commission, which will need to be reviewed by EU Parliament and by the Council according to the process in place within the EU. But what I have in mind is that the draft of regulation about artificial intelligence is referring many times to GDPR, and especially regarding services to be provided by a third trusted party, sort of certification, because provider of platform, of provider of certain IT services will need to be certified in order to share personal data and within the list of requirements which need to be complied with by the applicants to get this certification on the data governance. there will be compliance with GDPR. So this future regulation, this bill, will refer to existing GDPR as one of the regulation of data in the field of artificial intelligence. But that's really preliminary comments because it's still under discussion.
Thanks a lot, Professor. On that note, we will close the session. We have run out of time, or we might say that we are exactly on time at 4:20 local time. But we have another session. We have the third session of the conference on meeting the challenges in implementing data privacy rules and regulations. So we will request the audience to go through the third session also. With that, meanwhile, I will thank everyone, all the panelists, for taking out time from their busy schedule. I will thank the organizers for arranging this. And then finally, I will thank the OP Jindal University for providing us the platform to have this such a fruitful discussion. I will close from here. Okay. Thank you, and a very good evening to everyone. Okay.
Thank you very much.
Everyone. Thanks.
Bye-bye.
Thanks a lot.
uh, reached the third session of the conference, which we will be discussing the challenges for implementation of data privacy. And before I introduce the audience to the excellent set of panel members, just wanted to very briefly kind of put in context, perhaps what we'll try to do in the next 1.5 hours. Very few things, about the pandemic can be said in any positive note. But one of those definitely has been almost by forced inclusion in terms of our daily lives, the use of internet. I just checked up a few numbers before before our session. Uh, India's internet penetration grew approximately by 1,300% over the past 2 years of the pandemic, which essentially means as more and more Indians are using the internet, more and more data is being left on the net for consumption by others. And a disproportionate amount of that data is emerging from rural India. Over the past year, the rural internet grew by 20% as compared to an urban internet, which grew only by 4%. So not only is this law and the correct implementation of any form of data privacy regime in this country essential for the data sovereignty of Indian users, but it is extremely important also for our businesses. Again, a disproportionate number of the unicorns emerging from India are coming from the tech space. So some form of legal clarity, I think, is essential with respect to the business models they develop. So what we will be, I will not speak a lot because we have an excellent set of panel members whom I very quickly introduced. We have Anand Krishnan, who is Manager Policy from Data Security Council of India. Thanks, Anand, for sort of joining us again. You've been with us even previously. Excellent to have you. Puneet Nagaraj, who is a Principal Associate at SAM, that is Shardul Amarchan. His practice area is in Public Policy and Regulatory Affairs. Thank you, Puneet. Parminder Jeet Singh, who is an Executive Director of IT for Change, and a very important NGO, civil society organization, which is again at the forefront of policy developments in this space. And we also have Manish Sehgal, who is Partner Risk Advisory Practice of Deloitte India. So as we have this entire spectrum of people, right from the people who are practicing to policy advisors, and especially both Parminder and Anand being involved in some form with the government in terms of how this legislation and this legal regime is emerging. So maybe I can just quickly go and begin the conversation with Parminder. If you could sort of, introduce to us a little bit about what, according to your experience, you see the challenges that India faces as it is emerging into this as the emerging structure, the legal structure of sort of privacy protection and data protection is emerging in this country.
Thanks, Virup, and thank you to the Jindal Global University for putting up this panel. So you have asked me an implementation question, but whenever I discuss privacy, I do prefer to step back because I think we need to understand the larger context of what we are dealing with here. This privacy word comes from an earlier era where we wanted our personal spaces, nobody to step on our toes. We want autonomy over a certain sphere of our lives and of space. Now, if it was that simple a question, then we can simply just say now when we have a data-based economy, we could just say that, okay, all data, no data should be taken from me, or even if data is taken, it should be extinguished immediately after an interaction is done. But that's not how it works. So the question is, therefore, that we have privacy on one side, and there is something else on the other side. Whereby the description which was put up for this panel talked about a balancing act. So we need to understand what are we trying to balance here. One is that personal space I talked about, which is now to be seen in a different manner than it was the physical privacy issues, the pre-digital age privacy issues, and I'll come to what it has become in the current times. And on the other side is that there is a digital society and a digital economy, and we want to get benefits out of it. And we are ready to immerse ourselves to get benefits out of it. And therefore, the balancing act is that we are ready and we need to give some data. Personally, there is a decision that, okay, I want to give some data because I want the social media to be targeted at me in a certain manner. When I want Spotify to target songs to me in a certain manner. When I go shopping, I want certain preferences already to be known, and this makes my life easier. But I've just mentioned three obvious things, but increasingly everywhere, whether it's an Uber taxi I'm taking or a payment system I'm on to. So I like certain data to be shared because I get certain benefits. Now, this is a personal choice issue, but society also wants, even if I'm not immediately getting benefit from the data which I share, the society at large wants us to share our data in aggregate as well, because the data economy works on data aggregates. A data society and a data-based governance system also works on these data aggregates. So both individually we want to share our data, and the society wants us to share our data. So the question is therefore how we protect our privacy, our personal space, our autonomies, and all shared data. So the question therefore is that we are ready to share data that is now, but we want controls over the data we share. We want to know how it is shared, to whom it is shared, to what extent, till what time, and what it would be extinguished, and so on. A lot of focus currently is on these individual choices, but there are also collective choices, and I have been a part of the Government of India's Non-Personal Data Committee, which we are talking about the collective choices and how we exercise on the collective data we share. And I think a good thing maybe to take the analogy of space. Increasingly, we are in hybrid virtual real lives and worlds where, like space was sacrosanct in a private sense, certain spaces, we have those spaces in the virtual space as well, whereby we can construct the privacy concept in terms of that virtual space. But going to the next point I wish to emphasize is that once we understand the overall equation or the problem, we should also understand that it is a fundamental problem of a very constitutional kind of a new society or a new economy in which we are setting up. The very nature of relationships in this society, economic relationships, social relationships, personal relationships, everything, the very fiber of the society is changing. And therefore, the kind of social contracts we did to manage personal physical spaces are now to be somehow changed, and we need some fundamental thinking at a social contract level, how our personal autonomies in data world would be protected and our autonomies safe, while we are able to participate in the data universe and benefit from it. The question would be of what kind of political form it would be, how much power we give corporates to organize the world. And right now, by default, much of our digital world is actually organized by corporations. And we allowed to do that because they only look like actors who are big, large, and powerful enough to do that organizing. And by default, right now, that's the world we are, though how slowly the public systems are trying to compete and claim some of the spaces here. So there will be a question of how much public systems, the NPD committee I was talking about talked about community data trusts as a system of data sharing, apart from the fact that corporates are the systems which today manage all our data. So the second part was that we need to establish a larger, more fundamental, first of all, before we establish implementation models, we need to shift to a very fundamental thinking about almost a new social contract for our data-fied and intelligence-fied, what we call as AI infused lives. And then we come down to the actual principles or actually implementation models, and they are on the legal side as well on the technical architecture side. On the legal side, I think we need to become a little more aggressive, I would say, to claim our virtual spaces as as being as sacrosanct as we claim our physical spaces. Nobody can break into our houses, and anybody who tries to break into my house faces a lot of criminal punishment. But that's not true of the data spaces right now. We are very kind of hands off on that side. I understand these are thinkings we are still forming, but I think we have to criminalize a lot of area where data related harms take place. The Indian Data Protection Bill does criminalize re-identifying anonymized data, and that's one start. One, as a principle level, we need to start thinking of many of those data harms like body harms or property theft or somewhere here. So like the law is about body harms, there is a law about property harm. We need to have a data harm pillar, which is a criminal pillar, and that's one important thing. Second important thing on the legal side is that we need global institutions and global law. And that has been another casualty of techno-libertarianism, that in early times when it was actually possible to develop global, maybe UN-based institutions about digital systems, we did not do enough work. Our institution, and I have been working on that, but there was a certain techno-libertarianism which says, no, let's not regulate everything. But today the world is largely getting techno-divided between two poles, one led by China and the US. And still there is no way to manage the digital systems without certain kind of global governance. I'm just touching the principles. So one is to have really property theft kind of criminal laws around data. Second, to have proper global law and institutions. And then at an operational level, there are many things, the kind of regulation, and I think my colleagues here on this panel are going to talk about many of these principles, and I wouldn't touch it. And then again, tech design wise, there is edge computing, federated systems, community ownership or local ownership of AI systems. All these, however, need to be backed by law. Voluntary systems simply don't work. We are in a real hard law space. As I said, we are in a new social contract space, but we still try to be very light about it. And I think the time has come, we think of many of these things in terms of hard law. A last point I would like to make is about antitrust and data privacy. Actually, currently, a lot of people think that data is safer in hands of big corporations like Apple and Google because they are the adults in the room. And if we allow a huge amount of data sharing, which otherwise looks like a good thing, more distributed data is actually more unsafe data. So that's another of a bipolarity which we need to contend with, but we cannot just because of that give too much power to the corporation. So these are the larger principles I wanted to lay out, which define the privacy versus digital benefits debate. And I'm sure my esteemed panels here would throw more light on the complexities of this space.
Thank you, Parminder. I think yes, it's extremely important as a professor at the law school. It's almost time where we have when we are teaching the issues of data privacy to students, you use the constitutional term. We often teach them using constitutional terms, and so the fact that we need a renewed social contract, a renewed concept of digital constitutionalism to understand how we have to operate this particular emerging legal regime. From those basic principles that Parminder helped us to understand, if I could jump, ask for almost like a practitioner's perspective and come to Manish, whose daily practice, of course, involves not only the fact that you need to have deal with data protection, but also the emerging issues of AI, Internet of Things, and big tech. So how in your practice, Manish, when you deal with your clients who are sort of worried about the state of India's uncertainty with data protection laws, not only from a personal point of view, as Parminder was pointing out, but also from the point of view of business clients. So if you could walk us through some of those experiences of yours, and how do you kind of advise your clients about about the Indian law?
Absolutely. Thank you so much, Arup, and thank you very much, Dr. Jindal, to organize and have me as one of the panelists. Just to confirm, I hope I'm audible well. Arup? Okay, thanks, Anand. Uh, I could not agree more than what Parminder said in setting the context. I think every of the point that he mentioned brought a policy perspective is bang on. And I will just pick up from where he left, which was creating the right balance in the implementation versus the regulatory angle as well as the social side of the equation. I think that's easier said than even addressed, Arup, I would say. Not from today, but for ever since the evolution of technology, if you see this fight or this race of striking the right balance continue. You will be surprised to hear that most of the time when these discussions happens at the business arena, where enterprises have some sophisticated solutions that can bring a lot of efficiency by the means of artificial intelligence or machine learning. Uh, the ask is usually pertaining that how do we ensure that we are right on the right side of the regulation? For which, Arup, even before I talk about the regulations, our recommendations are always that stick to the basics. Ensure that the basics are absolutely clear. If we are able to take the data fundamentals, or what we call data hygiene, in a place, irrespective of what the regulation is even asking for, I think half of the battle is won. And when I talk about basics, I'm just talking about the structures of our data, the lay of the land, how we govern the data in our enterprise, who is accountable for what, who is processing what. People even don't know, Arup, where the data gets processed, where it is originating from. Forget about any advanced technology for us to address it, right? So I'm answering the second part of the question. What do I recommend? I'm saying that I always suggest to start with the basics to get the right structures in place. And then there are regulations, Arup, there are currently in place or currently being discussed. For example, in India, we still have debate going on, but maybe the privacy laws around the world exist. But if you go globally, there is a whole debate going on about how to, I'll not say control, but how to bring the privacy balance or a data protection balance for advancements which are being brought by artificial intelligence in the space. I'm sure people who are interested in this subject would have read that I think about last 10 days, US has made some advancement of getting that regulation more tightened up. The Turkish Data Protection Authority last week released those guidelines. Why is it happening? Is it exactly happening for the same reason that all understand the potential of what AI can do to the human life, but at the same time, there's a triage of privacy, technology advancements, and what business and sectors can do from an economy enhancement point of view. There's always a bit of a drift that if the data can't be let out, how the machine learning can even start learning themselves to give a equation of becoming artificially intelligent. Because there's a law under the privacy which says, the principle of limitation, right? Which says that just ensure that you are restricting the data for the adequacy and the limitness for which you have been associated. You just can't prolong the association of data. But if during the testing phases of our machine learning programs, we require the data to go, there is definitely a bit of a conflicting view from the along. So long story short, Arup, I'll have much more to add, but for me, from an implementation perspective and to make the things easy, sticking to the fundamentals is very important. Technology enhancement helps to get it going right. And of course, one of the very important element is the whole ecosystem is about the human. Um, Quite often, Arup, we have been in situations, Arup, we have been in situations where enterprises spend exorbitant amount of money to get the right technology, which definitely helps them to control the things. But if the users and the staff, the employees, the people, if they aren't really educated and trained and made aware about the importance of data, the technology alone can't do anything. Often we have heard that humans may turn to be the weakest link in the chain. I always recommend with the philosophy, why don't we make them the strongest link in the chain so that they can augment the support of what technology is bringing to the table. And if people end of the day start appreciating the concept that Parminder laid down, and something I'm that alluding to, and I'm sure my co-panelists will also talk, that if we start respecting the privacy by design as the way we work, the technologies have a long way to go. And nothing very upfronting, even the basic design structures to start with, that can help us to get along. Rather than in a hurry of launching a solution and then figuring out whether the solution is right from an AI perspective or from a privacy perspective, or does it sit on the right side of the equation. So some more things to add, Abhiru, but from an opening perspective, I think these are the few things I wanted to bring to the table. Back to you.
Thank you, Manish. Anand, I will come to you. I know that and of course, I want you to speak about, as you said, conceptualizing and implementing a couple of these sort of privacy rights, specifically from an AI point of view. But before you could do that, I know that you have sort of participated with the government and in terms of the ongoing drafting of the data protection bill. I do not know whether you can share more than what you are permitted to, but are these conversations also happening within the government circles according to whatever you have experienced? When in terms of the design of the data protection bill, are a couple of these concepts, salient principles which Parminder laid out, are they even being sort of talked about, or do you think that the civil society and the government still has, they're not perhaps speaking on the same lines? What is your experience in terms of the how the government is looking at these issues when they are drafting the bill itself?
So I can thank you very much, first of all, for having me for the discussion. Um, in terms of, if you have sort of followed the data protection framework process since the inception, I think the focus has always been on creating a framework which respects a certain set of privacy principles. If you look at the second page of the white paper that came out in 2017, it lists 7, 8 principles, which will be the core sort of fundamental things that the framework will try to achieve: data minimization, control responsibility, etc., etc. And with the reformation of the right to privacy judgment, it became incredibly important for us to also operationalize these different aspects of right to privacy through the frameworks that we try to create. Even in the privacy bill at the moment, we see that there are specific principles that have been laid down in the framework, in the bill itself. And these are punishable and sort of contraventions if an organization is found to be in contravention of not putting in steps to operationalize these principles, such as data quality and sort of other principles around informed consent and notice. I think the sort of disagreement starts, or the point which I think globally has become a matter of debate, and I was going to sort of comment on it in my third intervention, but I think it's an important aspect here, is the point around balancing sort of national sort of considerations around security as well as privacy, and where sort of these exemptions, or to what level exemptions need to be provided to national agencies, while sort of to sort of enable them to carry out their activities, but at the same time maintaining some level of governance around how any sort of exemption would be utilized by the government. I think that's where a lot of the debate, if I may sort of talk about from a civil society perspective and government interaction, has been around. And this has become an even sort of greater issue if you look at it in the context of the post-Schrems world that we're in at the moment, where governments are sort of questioning other governments in terms of possible snooping activities on their citizens' data in sort of another geography. And this question of access to foreign nationals' data has become a very important topic, not just from the perspective of, let's say, citizen and government sort of fundamental guarantees of privacy, but also matters of large diplomatic relations between nations, as well as data flows, which have become also a very important portion of the larger dialogue around data transfers. I won't go deeper into that, and I'll sort of stop it there as my initial intervention on that point. Would you like me to sort of continue and cover the other points?
Maybe why don't you just because I know you wanted to speak about implementation about data and privacy rights in the context of AI or artificial intelligence. So why don't you kind of maybe cover that a little bit more and then I can go back to Puneet.
Sure. In terms of, I think it sort of is, I'll take sort of a couple of points from what Parminder and Manish have been talking about. Uh, at DSCI, what we try to do is we've been working in this area since 2008, and we've been working in this space where there's been a vacuum. There was no privacy rules even at that time. What do we do in such a situation where there is no possible guidance or regulation? There weren't even like global standards that people could mimic. What do you do in this situation? What we found was that if you create sort of frameworks and guidance material tailored to sort of help out people who would actually be tasked with the implementation exercise, that is the best way to sort of build privacy within sort of a society, within sort of, let's say, I'll talk just about the corporate culture even. So to that, sort of keeping that in mind, and sort of I'll talk a bit about the work that we're doing. We've created this AI handbook, which focuses on this largely sort of giving sort of the developers a sort of a structured manner in sort of incorporating ethics and privacy in the overall development cycle itself. And that is just a approach that I'm actually personally a big fan of, this practitioner-led approach where you try to incorporate these things into the behavior of the individual as they sort of go around developing these pointers. And sort of very much in line with what was being said earlier. Uh, and, my final point in my intervention was going to be around specifics of sort of privacy rights, which become incredibly important in the whole context of artificial intelligence and largely data usage. Are these core principles of data quality and accuracy to just start things off really? That's basic sort of importance that need to be given to the data curation and then the sort of arrangement of the data and maintaining the accuracy, because we know what kind of sort of outcomes that come in if we have sort of inaccurate sort of data processing, or if you're relying on data sets which are not giving a correct representation of that aggregated set of people or population. Another important right that I thought would be great for the part of the discussion, I would love to know everybody's opinion here as well, is that when the whole conversation around what rights to incorporate in the Indian sort of privacy framework was being discussed, one of the couple of rights people were kind of on the fence in the whole discussion. One was around data portability, and the other one being right to subject to automated decision making. And ultimately, the decision was making that right to portability would be one which we would incorporate, but the one that we would drop would be right to subject to automated decision making in India. And right to subject to a sort of automated decision making is essentially an inherent portion of the whole AI sort of ecosystem. And I would love to get everybody's thoughts on that as well. And yeah, that's it for my initial intervention. Thank you.
Thank you, Anand. Puneet, thank you for waiting. I'm coming in at the end, but I am deliberately doing so because I want somebody who is a legal practitioner tell us a little bit about Manish has kind of walked us through some of the challenges, but we still don't have quote unquote privacy law in this country. So how, when you're drafting contracts, when you are drafting compliance programs for companies, for clients who are at this cutting, or who are either in the realm of AI or is related to it, as most businesses would be, how do you go about doing it? Like, do you transplant sort of our traditional laws in this context of AI? How do you do that? And again, some of the challenges that you face, which should be brought into the mainstream in terms of the conversation while we are building this privacy structure, the legal structure for ourselves.
Thanks, Avirup, and Anand, Parminder, and Manish as well. That's a very interesting question because this is something we do grapple with as practitioners. Because it's well and good to say, this is missing, this needs to be legislated upon, but when you get down to the nuts and bolts of it, a lot of the times you are extending rules that were not really framed for the technologies you're dealing with. For instance, telecom regulation is still regulated by the Telegraph Act in India, for instance. And we're in this sort of weird space with data as well now, where we have a PDP bill in space. There's cutting edge research going on in India, outside India, that's impacting Indian citizens. But largely we still operate by what's called the SPDI rules, the Reasonable Security Practices rules under the IT Act, which served its purpose for maybe 20 years ago when the IT Act was new, and I think 8 years later is when the SPDI rules came into effect. But it's definitely not very useful in terms of thinking about, if like a technology company is looking at releasing the product, if you're looking at what sort of harms it might cause, or, what sort of things you want to guard against when the products are released, it's not a very useful toolkit, so to speak. So what ends up happening, as you rightly pointed out, is a lot of this goes into contractual language. A lot of this goes into, internal compliance programs where there's a number of checks you undertake, where unfortunately, more often than not, you start relying on GDPR standards because some people are just more comfortable dealing with the higher standard that, can give you some amount of insurance against, possible claims and things like that. But one thing I will say though about something like AI, and I think this speaks to Anand's point earlier, is it's one of those strange areas where the companies themselves are aware of the need for regulation and sometimes are pro-regulation in a sense. So when you speak of things like privacy by design and having in place and thinking in terms of the harms and thinking in terms of the consequences of processing data, that's already happening. As you may be aware, most big tech companies have an AI ethics teams. They have, AI principles that they all sort of ensure that every product review must happen. And we do as lawyers from time to time play a role in that. So it becomes very much part of the design thinking at the moment you start thinking of a product itself. So you start thinking, as I mentioned, what are we using this data for? What possible harms can there be from processing this data? Where are we, crossing the line a little bit? And again, you could, as Parminder said, speak of the benefits of this. You could argue that the companies process a large amount of data, so they don't need to take a certain amount of responsibility. But, and that's a fair point, but there's only so much companies themselves can do. We do need a sort of updated toolkit, as I mentioned. The PDP bill hopefully will be out soon. And there are lots of very useful principles in that have been fleshed out in an Indian context very well. And to a point that you had mentioned at the very outset, we're dealing with a country where, consensus, and this is not in any way specific to, technology regulation or to data privacy, where consent does not mean the same thing that it would in many other jurisdictions. Getting people, literate with technology, getting people to understand what the use of their data is itself is a big challenge. But at the same time, there are a lot of things that give me hope because there's been a lot of innovation in this space. If you look at something like UPI or the account aggregator framework, they're very much Indian innovations that have relied on the processing of a large amount of sensitive data. Like UPI relies on financial data being processed, but I would argue that that's a very big success, and we have been able to put in place sort of frameworks that sort of support it. But until you have a privacy regulation, it's always going to be walking on crutches. You need a sort of a more well thought out framework. I can come back to the AI questions later, but I think that's what I have to say to sort of take this off.
Yeah, Puneet, if I could just be with you for a little longer and kind of ask you, because I can't sort of speak about Indian law and privacy without talking a little bit about antitrust and what Parminder kind of hinted at. Of course, as we all know, there's an ongoing investigation in terms of WhatsApp privacy policy. So again, from an antitrust point of view, I know you are not specifically an antitrust lawyer, but you have to deal with all of those issues also. How do you when your client comes in, because CCI is often unpredictable as to how it comes up with some of its regulations. How do you look at this new intervention by the Competition Commission? Do you think that they will go down the same lines as European Union in terms of Germany or Austria, or do you think that they will be much more conservative?
Thanks, Avirup. And I really want to caveat this by saying I'm not at all an antitrust lawyer. It is not an area I specialize in. I have very capable colleagues who deal with this. And a very simple answer is when I get those questions, I just pass them on to them. But if I can take a stab at answering it, I think the more fundamental question when it comes to antitrust is that technology companies have posed a different kind of challenge. So if you look at what happened in the 90s with Microsoft and stuff, those questions like bundling and things like that. Whereas now, and I think the draft e-commerce policy that came a couple of years ago, made an interesting point that having a large amount of data itself can be anti-competitive. I think there's a little more nuance. There's a case for a little more nuance in that sort of thinking, because it's not just having a lot of data, right? For instance, we do say India is a data-rich country, but the size of our data economy is not really comparable to the more developed countries, and for various reasons. So would you just start off by saying that a company that has a large amount of data should be regulated? Or is it, the practices they engage in? Are they engaging in anti-competitive behavior? Where do you redraw the lines? I know there's a lot of conversation. I think NIPFA have written a great paper a while back on using sort of I think public utilities analogy to start regulating technology companies that provide public utility services. Can that be, reframed into Indian law? That concepts that we can borrow from there to use that is an interesting question to me. On the question of what CCI is doing at the moment, again, I'm not qualified to comment on it, but I would say that you have to again look at what behavior that companies are engaging in that is harmful to the consumer. I think a lot of times, and this is not unique to the CCI, many other regulators as well say that they're acting in consumer interest. But what that consumer interest, in articulating that consumer interest and what they're safeguarding and how their decisions sort of protect that consumer interest is where I think we get lost in the weeds a little bit. So I would imagine for a lot of these, and again, the Consumer Protection Act is a good starting point, for instance. I think you need to start there because a lot of these technologies are user-facing. So I would take a step back and start there rather than looking at what the CCI is doing. Because a lot of those issues, and that's the other thing about technologies, that they end up being cross-cutting. There could be 7 different regulations that could hit one particular question.
Thanks, Puneet. Thank you. So again, if I could go back to Parminder and where we kind of left in your previous intervention. Parminder, I think I'm a little curious to sort of in our experience, a couple of these things that you just highlighted for us, it's extremely important, the fact that we need to look at the digital economy, the digital society through a new lens of legal rights, a new prism of a new social contract. But my question to you is that it is new for our country, but there are jurisdictions, for example, Europe, where this has been going on for a pretty long period of time. Do you think what has hindered in terms of, for example, building of global law, global institutions, as you were pointing out? What has hindered in terms of developing at least a framework of a new social contract, which we could have then adopted or benefited from?
Okay, so while you say this has been happening in many other places, I mean, the other places may be far ahead. That may not really be true. That things actually have changed so fast that even companies like Google and Facebook around 2009-10 did not really understand what the data game and AI game is going to be. And they openly do admit some of these things. They were largely, they relied on what we call as network power, less than on their data and later on AI power. And they have been discovering, and so has been the West or the so-called developed countries. Now, for example, the collective data rights thing, which our non-personal data committee has done, is something the West has simply not done anything about. This is very funny that they simply refused to touch the issue of aggregate data. Aggregate data is 80% power of AI engines. Anybody will tell you who understands AI, that AI is looking for patterns. It is not looking so much about what Avirup does in his personal time, which they will find out separately. But their real work is to find patterns, and finding pattern is about aggregate data And there's not a single framework globally around aggregate data at all. The NPT committee was the first one to try to do that. But your question is, why has it not happened? And I did touch upon it a bit when I was talking, that there was a certain techno-libertarianism in early periods where it was being said, no, don't touch it, don't fix which is not broken. And for a long period, that kind of thinking has ruled. And I can, mentally break those periods before the millennium, then the first decade of the millennium. And only in the second decade of this millennium, we have started to talk about, and seriously, everybody is saying, no, we need to stop and do something at a fundamental level. First of all, when we stop being techno-libertarians, we says no regulation, nothing, let them do whatever they're doing. Second stage comes when we have to take political choices. And that period is not still, and you as a professor of law would understand, is a serious thing. Now, we've still not gone past that feeling that technology space is somehow an uncontested space where political philosophies don't apply. That's not true. What role a corporation would have in organizing our affairs is a political decision. Different countries take in a different manner. China has been taking in a different manner. US has been taking in a different manner. Merkel in Germany had some middle path philosophy for some time, largely in words, not in deeds. So I think, and that's why my discussion was that we should step back and understand that this space is as political as any other space. Different nations, different societies would have a different political take to it. Make your choices and don't be blinded by thinking that technology is somehow a non-political space, first of all, or non-regulation space, or even if it is political, then somehow same politics applies everywhere. No, these are not true. And I think we are still caught in not understanding those things. And once we understand that and our choices start drawing from there, we would be much better off. And the reason the West is not doing is that it wants to, as the US wants, to use the digital as its new way of expansionism. It's the digital expansionism. And they want to perpetuate this thinking till China came around, that there is nothing about digital politics. There's no politics in digital. There's no regulatory requirements. There are minimal protection related requirements, but nothing positive is needed and so on. I think this is the context whereby things have not moved fast enough. And I think if we need to move fast, we have to layer it. And the legal profession, the constitutional experts, the political experts who should be doing their work, and downstream then the implementers and the regulators and technology guys, they should come into a framework and do together.
Yeah, thank you for an extremely important points being made there, that, in terms of how perhaps it's one of those very rare occasions where we have come down and started discussing about the legal principles without understanding the political legal philosophy behind why we need that law or how to go about sort of implementing that law. Manish, I know a lot of your practice kind of includes, the way AI is being used for providing, mass access to healthcare and sort of medicine and some of those issues specifically as we are emerging out of this pandemic. I want you to speak a little bit, if you can, about your experience in kind of in that space, but also to what extent you see this all as a regulatory challenge as we move ahead and we start using sort of AI for a lot of the access to medicine and healthcare would be one of them. But there could be several other sort of public use of AI, which perhaps could be implemented in the near future. From your point of view, what are the challenges that you perceive, and what has been your experience in kind of dealing in this matter?
Oh, thanks, Avirup. So, Roop, I'm sure you will appreciate I have to keep the confidential details away from our discussion. But you picked up a couple of points on AI usage in medical slash access to the healthcare, and how the whole pandemic ended up leveraging it. So I think it's no more a hidden truth that what pandemic did to the digitization, nobody has done that. And for very understandable reasons, AI was definitely at the front guard of helping us to define it. We have seen many examples of how the contract tracing applications became so important means to ensure that the disease or the infection is contained. But then, of course, at the side of the equation, there were concerns about what happens to the data that is being collected. Is it being anonymized? Will it be there for eternity? Who will be responsible if there is a data loss, right? So, as I said, that for very understandable reason, there are needs for us to go out, get in the production live environment quickly. But the fundamentals, which Parvinder, Puneet, and Anand have alluded to in the previous discussions, may not be the front runner when the discussion comes along. And that's the reason why principles of privacy by design or say by default becomes very, very important. A very interesting concept, Avirup, which is coming, which is gaining traction. Again, I'm not sure how much people have read about it, is about human rights by design. And it is something which is very important for organizations who are adopting AI or ML, either as a part of their own enterprise efficiencies or for end user efficiency. Now, when human right by design is taken as a principle on which an enterprise works, all the aspects of social balance, human rights, digital, I mean, the rights to me as a data user, they all get incorporated. And every step of the progress that a particular AI solution or a product may take will have to abide by that. It's easier said than done. Privacy by design itself is one of the most difficult things that we see, and I'm sure my co-panelists will agree. Forget about human rights by design, which will be taking the whole discussion to the next level. But this is what is happening. Third point I would like to make, Avirup, is that few countries, and since it is public, I can share, this was one of those which used a very sophisticated AI product to start identifying the people who were getting into the country to test or not for a COVID infection perspective. And the reason was very understood. Like most of the countries, they didn't really have large infrastructure. So how do they really make out who to test, who not to? And that's where they adopted going out of the way of their neighboring countries of adapting AI, who would be getting intelligent day by day, hour by hour, minute by minute on various parameters, including the origin, age, gender, nationality, and suggesting to the officers at the airport whether to invite a particular individual for a RT-PCR equivalent test or not, rather than doing a random test which may not really yield the results they are doing. So they are doing tests on a count basis. So Greece is one of the examples to quote where actual implementation of that particular technology has done precisely for the COVID and the pandemic reason. Uh, is this a great way of benchmarking? Answer is no. There are still discussions going on with the different schools of thoughts about what even that is being done is right or not. But I just sort of bringing this as an example because that's public, and even we as practitioners, as researchers, end up reading things around it. Last thing, uh, how to go about addressing the challenges? I don't think there's a straight answer to that, Aviru. There have to be multifaceted approach, which requires this to be addressed at different angles. Uh, I think why there are difficulties of AI solutions to be gaining a momentum, why countries like US or Turkey, as an example that I gave, who few days back released a data protection authority released a guideline, is precisely for the reason that uh, biased decision making could be stopped. Very simple truth code about Aviru, garbage in and garbage out. The data that goes into the testing and development of an AI solution, if it has any sort of prejudice, that will eventually make the artificial intelligence program or the algorithm prejudice also. Without mentioning the names, there were news items which actually called out, and they were giving examples of GDPR's point of automated decision making. That there were instances where the AI algorithm which was put to screen the applicants in an organization for a job, for some reasons, the ones who were not white, they were bifurcated slash put aside, which is a classic example as to how uh, what sort of a negative impact the AI solutions can make in case the so-called the data is not really taken care of well. Another example to quote was, again, which was in public, but I won't take the name, is that how the the credit worthiness of an applicant was question mark and the loan was not granted just because of the parameters of their rate. So all in all, what I'm trying to say is that Arup, these fundamentals still have to be really rattled out. I totally agree with Parminder where he mentioned that there may be belief that the Western world is way advanced. I think if that would have been the case, we would have seen some live examples. We within ourselves are struggling to suggest where those have been rightly balanced and fit, but it's a journey that will go on. Few of the examples and principles that I just were my 2 cents. Back to you.
Thank you, Manish. So, if I could now come to Anand, then I think I want to also touch a little bit about this area about data transfers. Now, with I think Parminder and everybody else, I mean, not Parminder specifically had sort of talked about China. And, this concept of data protectionism is not something that has been for the first time been introduced by China. That's not true. In fact, there has been political movements even in our country, which kind of hints towards such a political strategy. Given the experience that the United States and the Europe had in terms of their understanding of their bilateral understanding in terms of data transfer and how that experience taught us lessons what we shouldn't do. What are the if I could ask, what are the challenges as well as expectations about global data transfer, at least bilateral data transfer? How do you perceive them? Do we need an international legal regime for that? Can that be done bilaterally? What are the challenges? And again, what are the expectations?
Thank you. Thank you for that very, very interesting question. I think in terms of just over the last 3-4 years, it's been a very, very clear movement of sort of moving away from any multilateral commitments that exist in terms of especially data transfers. We saw that with even the Trump Abe proposal of data transfers with trust. India and China sort of coming together and saying that both of them saying that they won't be part of something and they would want to enforce some level of sovereignty around their data use or data regulation even. I mean, it could just be sort of these different dimensions. But it would be wrong to say that was the only attempt that has been made in history to have a global regime for data transfers. There have been several, the biggest one being the most foremost being Convention 108, where several countries did sign on, but other countries such as India and other geographies had certain apprehensions, especially coming from a sort of a colonial background of being subject to a certain decision of sort of a foreign sort of authority. And that was one of the sort of initial apprehensions that existed about sort of going towards a global sort of approach. And now we have seen very much move towards a bilateral sort of agreement sort of approach. And the way that the bilateral approach is also to be looked at has evolved. So if you look at the US approach, they do want something which is bilateral, but which is connected to a more multilateral instrument when it comes to industry data transfers. Say, for example, the APEX CBPR framework. So what the expectation is that a national law has the possibility of recognition of codes of practices and certifications for data transfers like the APEX CBPR industry rules and allowing for transfer to take place while the agreement has been through bilateral means, but there is a multilateral sort of agreement which is there that allows for industry to industry transfer sort of taking place. So we've seen this sort of new evolution happening. The other sort of, I think these generally I've seen across newer legislations that are coming up around the globe. Several countries are now also very much incorporating this adequacy decision or government assessment approach, where very much the idea is that the country itself doesn't unilaterally decide or unilaterally look up somebody's law and decide that they are an adequate nation or not. It is a nation, say for example India has a privacy law, then they would make a formal request to the European Union to start an adequacy finding and sort of do an assessment, etc., etc. So this adequacy approach is something which we've seen very much take sort of prominence. And it has also seen a bigger push from the European Union ever since the newer framework of GDPR came in, with Europe also actively trying to sort of seek these partnerships in the sort of in Asia as a geography as well as Africa. If you look at the sort of recent sort of statements that have come out of the European Commission as well as the UK at the moment, that they would be engaging in diplomatic missions, etc., over the course of 2 years, creating these bilateral relationships with these other Asian countries. We've already seen Japan has been given a reciprocal adequacy decision under EU GDPR, and Korea is pretty much on the way as well. So that is fundamentally the instruments that we're seeing. The problems, I would say, is I think the biggest one, like I mentioned, was around commitments that the domestic governments need to provide, that their national security agencies will not engage in any sort of snooping or access to foreign nationals' data while it is within a specific of their domestic territory. I think that's where the major problem lies. And the everything else, I believe, I think is something which can be utilized if we sort of follow the approach that is there in the adequacy decision and utilization of supplementary rules, which I think everybody baseline globally agrees. So India it wouldn't be a problem if India doesn't have trade union memberships recognized as sensitive data in India. Only thing would be required is that as part of the transfer sort of treaty that we sign, India recognizes that they would sort of respect sensitive data, or they would include sort of as a special reference trade union membership. So that's something that can be resolved at supplementary rule level. But this national security access is not something which can be resolved at through the supplementary level. There needs to be certain government to government guarantees that need to be given, and which is something that is not something that I personally cannot predict as to how it will shape up.
I'll come to Puneet, and Puneet, after your comments, I'll open up to questions. I've already received a couple of questions. There seems to be a lot of questions. Uh, uh, Puneet, we have been speaking for almost more than an hour about privacy, and that has been, of course, the theme of this panel. But because we have your expertise on the panel too, if I could kind of go a little bit, push the envelope a little bit more, and think about, ask you about defining some of the legal harms or the legal risks that you face in terms of advising with businesses embedded with AI, emerging tech. Uh, how do you think future regulation in this country should look like? Because the privacy act or the privacy bill, whatever they call the act, would be one of those pillars, but that cannot be the only one. Uh, I began with that initial remark of mine that a disproportionate amount of the new age businesses coming up in this our country will be using AI, or will be using emerging tech. So how do you think the future of regulations in this space should look like, or ought to look like?
Thanks, Aviru. I think, you know, I, there's a couple of ways to look at your question. One is, from a process point of view, from a procedural standpoint, what would the rule making process look like? And second is, just from a substantive perspective, what would be the content of those regulations, right? And I'd spend like very briefly discuss the contours of what this might look like in terms of process. The larger question we should ask is this the right time to regulate AI? The PDP bill is in the pipeline. Do we need more, as I mentioned earlier, more fundamental principles to be laid down? Would we end up over-regulating a growing technology that needs some time to breathe? Are there existing principles, as I mentioned earlier, that we can extend until then? Do we need, the IT Act is the greatest example of that. It was enacted at a time in response to the UNCTAD global e-commerce declaration that India need to put in practice for very sort of commercial reasons. but it has not, very quickly became outdated. So with technology regulation, especially, you're always playing catch up. So one of the things I really like in the proposed PDP bill is this idea of the regulator issuing codes of practices from time to time, issuing sort of guidelines on how privacy by design framework might look like. There's no reason why something like that cannot extend to AI, for instance. And this is a practice that's followed, in Singapore, Canada, and many other jurisdictions, where until you get to a point where you feel like there needs to be legislation that hard codes how technology should be built, how data should be processed, I think we can get by with these sort of directives from time to time, because, as I said, we need to wait for the privacy regulation. We need to learn how to walk before we start running. And the second part of the, the procedural question that we always ask in India is to have more transparency in the process of rulemaking as well. And again, this is not unique to technology. And with something like the PDP bill, it was largely a transparent process. But, if a provision turns up in the final draft of the bill that was never part of the conversation at any point, or if, there isn't enough sort of explanations provided for why a certain provision ended up, what the purpose of that provision is, I think it creates a lot of uncertainty. So I think, again, when you're speaking about AI, because it's such a critical technology, going back to the Niti Aayog strategy document from a few years ago, it is a technology that the government is also interested in sort of developing, making India a hub for this sort of technology. It is important that we handle that development with care. Having said that, as a lawyer, coming to the substance of what must be covered, AI, again, as I mentioned, is one of those weird areas where the companies themselves are asking for regulation. So the risks of harm is not lost on anybody. The trolley problem is the one that everyone discusses when it comes to handing over decision making to a machine. But at the same time, there is a lot of social good that comes out of AI as well. So again, going back to the taking a leaf out of the PDP framework, I think a lot of legal risk, or to say, a lot of liability surrounds the question of harm. But what we don't have in the PDP bill as yet is, what that harm could mean from context to context. What is the extent of that harm? Are there layers to the harm? So if you look at the proposed EU legislation on AI, there's 4 categories of harm, right? I think it would be very helpful to follow a similar approach in India, because there's large categories where the existing SPDI framework, for instance, of notice and consent would be more than sufficient. It would be, things like Parminder mentioned, if Spotify is organizing my playlist in a useful way for myself, is that necessarily a bad thing? Give the keys back to the consumer, but in a way that it also makes it easier to process these data. But, when you go to the other end of the extreme, where the data is being used to commit crimes, where, there's bodily harm, there's very clear-cut cases of, financial fraud or criminal penalties that should, you think would be in a red category, where there would be criminal penalties attached to that kind of conduct. And that's, very normal for that sort of, for privacy legislation, or, any legislation that regulates tech, to have those sort of provisions. But, and then you perhaps have, and again, this is in the PDP bill, processing that could perhaps lead to discrimination and things like that, resulting in sort of civil penalties or discrimination cases and things like that. A lot of this exists in the existing legal framework. We have criminal laws, we have the constitution that lays down the sort of guardrails for equality, discrimination, and things like that. It's a question of translating that into the specific context of AI. Which is why, do we need a legislation to do that? Would rules and regulations suffice? If you look at, a lot of things that the TRAI and MeTI are doing, the Ministry of Electronics has been doing off late. They're promoting a self-regulating framework. In some cases, it's a co-regulation framework where the government lays down broad guidelines and companies, sort of implement them. There's a penalty framework. There's many different ways to sort of slice this cake, but we would need, as I keep mentioning, the base of the PDP bill to become law for us to, start having those conversations in a more meaningful way.
Thank you, Puneet. Before I can go to the questions, if I could just sort of close our discussion with asking each one of you, because our topic is meeting challenges and implementing data privacy. If I could ask each of you to identify one challenge which you think is paramount from your experience, in your opinion, that should be dealt with first. If you could sort of point out one major challenge, according to you, the most important challenge in implementing data privacy for a country like ours. Parminder, if I could start with you.
Let me come in later. I'm not able to think of precise one implementing challenge. There's so many of them, but I'd come there.
Parminder, if you could kindly speak a little bit. Yeah.
I said, come at the end of the queue. I'm just thinking about that one implementation challenge.
Okay, sure. I just said one because for lack of time, you can of course add more. Yeah, Manish, then I can just go to you. According to your experience, the most important challenge.
Most important challenge with respect to implementing privacy and data protection controls is that what you mean?
Yes, the most important challenge in implementing data privacy in India.
Okay, so for me, it's the people. That's the biggest challenge. And whenever I am interacting with corporates, uh, after various discussions, most of the time, boards or the senior executive would ask me, Manish, what is that one thing that you want us to do? Because you have given us a plethora of activities to perform. I just walk out saying that make sure that your people are groomed to appreciate privacy. That's the biggest challenge. And I alluded upon it during the course of my first intervention as well. And the reason being, you can get best of the consultants, you can get best of the technologies, but what you can't do is get an overnight change in the way people look, address, and accept the data. For years, we have been using the data in a particular way. People's psychology and changes are the most difficult and time consuming to have. One of the board executives for a large enterprise asked me that, Manish, you are recommending us to start preparing for the privacy bill law, but it is still in a bill and it's not a law. And one of the points that I have mentioned is that people's psychology doesn't change as soon as the bill is converted into a law. We have to have that mentality, and especially we do nothing good or bad about it, but we as society, we at large are still developing ourselves to start appreciating privacy. Privacy is not taught us in school. We don't get to hear much of privacy aspects in our family at large. So for me, if that's the one thing that you're asking, which is the most difficult thing, it is the people element, and we have to work towards making that weakest thing the strongest thing by doing awareness trainings and educating again and again, and helping them learn the aspects of privacy. That's my take.
Very interesting, Manish. Yeah, I mean, that has been India's experience in many areas of law. We can have the best law in place. How we get to use that law, or how we get to sort of the people kind of sort of implement it. It's the the biggest question. Anand, if I could come to you, what according to you is the biggest challenge?
I think the biggest challenge, without a doubt, is having an active and accountable regulator. I think that's fundamentally that everything boils down to. I think everything we're trying to accomplish will not go anywhere unless we have a well-staffed, funded data protection authority, which is willing to sort of coordinate and sort of have open conversations with the government stakeholders as well as the industry stakeholders. We've seen globally, the GDPR implementation experience for companies across Europe has also been very varied. It depends upon how the regulator, how active the regulator is in sort of while implementing the legislation. When we sort of create we call it regulatory compliance intelligence, and somebody might call it something else. These are 7 laws that a country has or whatever, right? And your operation is subject to 7 laws, and you create like a threat sort of thing. This law has this requirement, this requirement, this requirement, whatever. At the end, you always put or actually sort of qualify the threat by how active the regulator is and what kind of decisions they've been taking. In India, we've had the SPDI rules for so many years, and the level of active compliance. I say active compliance specifically because there are other people who might be in incidental compliance of the SPDI rules because they're trying to implement something. But there have not been several people who have been actively trying to comply with that because there is no regulatory action. So that's what I would sort of have my final thoughts on. It is to have an accountable regulator. That's all.
Yeah, again, that's building up regulatory institutions. I have myself worked with the Competition Commission in its initial years. So that's one of the fundamental challenges, of course, specifically the way in which our regulators often work. Puneet, again, same question to you. We need a good regulator. We need to be better human beings or better people. What do you think we should do better for regulating privacy in our country?
I think I think my answer might end up being slightly similar to what Manish said, but as a lawyer, I try to make it as specific as possible. I think what consent means in India, as it said at the very outset, it can mean different things to different people. We have varying levels of literacy, development, and things like that. So the interaction with technology makes all of that very complicated. And this is where I think the Sri Krishna committee sort of missed a trick, because they sort of identified the problem by saying, and this is again an issue that exists in most commercial laws. Well, what can consent mean? People can turn up in courts 15 years later and say, I never consented to this. They said that for privacy, consent is the sort of linchpin around which a lot of the regulation is going to revolve around. And they said it needs to be simple, it needs to be accessible. There is such a thing called consent exhaustion, where like I don't know that anybody sits and reads all the privacy policies that I have draft. But there is a need to make the consent process simple and accessible. But if you look at the final draft of the PDP bill, it has, if you look at clause 7, which says these are the things you need to specify when you're taking consent from someone, there are 14 different things. Now, when you're quickly trying to access a website or an app, how many people actually have the time to look through that consent? So even if you control for things like literacy and technical literacy, even as a lawyer, like I said, I don't read through the clause necessarily. How many people have that kind of time? How much of that consent, as we say, is consensus ad item? How much do people actually understand what they're consenting to? That to me, I see as a possible stumbling block already before the PDP bill comes into effect.
Yeah, so if I have to, before Virup comes, I give a broad sweep, agree with all the three people here, but I will combine it, whether to educate people as Manish and Puneet want, or the regulatory actual decision making, which Anand talks about, and I think is very important. I think we need to be more consistent with the societal objectives and what directions, why we are doing it, what are the pros, cons, what are the larger reasons. It's not just a law, and that's why we are doing it. Regulator also needs to understand when the regulator takes a decision, and whether education takes place. What Manish is saying, we need to have our social objectives, our social choices, and this kind of larger principles building is to be institutionalized in India's systems at academic levels, at IITs, in social science places, and government should set up those kind of things. I think that has to grow for people to get educated and regulators to have a basis to take good decisions. And I think, therefore, with a broad brush, I agree with these three things.
Thank you, everyone. So I think, I'll turn to a couple of these questions, and if we have towards the end, maybe I'll add a few questions of my own. Manish, there is a question directly related to some of the issues that you just highlighted about how we as individuals, as Indians, we need to kind of sort of change our understanding of how data is used or how precious data is. One of the questions that I have that I can see on my phone is that should we give a couple of years to the PDP, that is the bill or the act, after it is passed, like that we have seen in the case of GDPR? Should there be given a few years after it is passed to kind of provide what you were suggesting, training up or consensus building, maybe government initiated, maybe civil society initiated, before the law actually gets implemented?
I'm sure Anand will have much sharper insights to share. But 2 points, Avirup and whoever asked this question. So very likely the law will have so-called cool-off period, or that implementation time. GDPR gave its own time of 18 to 24 months, and even the first bill, the first version also indicated something on the similar lines. It is very likely that there will be that duration for corporates to prepare themselves. And more important, if you heard Anand well, he said that the most important point to make this successful is to have a regulator. The government doesn't have a regulator yet. Even they need to have a regulator. So it's not that they will implement, pass the bill, tomorrow law comes and becomes effective. So if you don't even have a regulator, it won't happen. And we all know that regulator can't come to existence in short span of time. So both from government as well as from corporate world, there will be a reasonable time. What it is, we have to wait and watch. But what I don't agree is that we should not wait for the bill to be announced. Now that the 2 years have been given, that's when we start working on the problem statement. That is what I'm trying to educate and hit hard again and again. That will not happen. There are organizations who have embarked their privacy journey outside India couple of years back. They still struggle because it's very difficult for the people mindset to come. That's really what my response is, Abhirup, that very likely the so-called cool off period or implementation time will be there in case Anand has anything he can add. But I highly recommend that we should not wait for that to happen and really start our journey right now. Human psychology and the change is one of the last things that will turn around within a given span of time.
Yeah.
Thank you.
Yeah, thank you, Manish. Anand, if you want to add to that, and there is, I think, a specific question for you as well. Adequacy decision takes a while, about 15 odd countries featuring in the EU list. Till that time, do we need to follow standard contractual clauses or other similar arrangements? I'm presuming that the person asking the question is looking from the data transfer point of view.
Sure. I'll first answer the question a bit that Manish was answering. We as DSCI have recommended a 2 to 3 year time period. I think that is the general accepted industry consensus that post GDPR, the industry has become a more proficient in sort of privacy implementation. The 2 to 3 year timeline is something which is good. Uh, what any sort of timeline that ultimately they settle on should take into consideration that outside of the companies or institutions that have had GDPR exposure, there are only few really. I mean, if after the privacy bill comes into the picture, you will have government schools trying to comply with this legislation, small offices, etc. And those people would require a lot more time and hand holding in that process. So whatever ultimately is decided, these things need to be taken into consideration. From the initial draft, what we can sort of take is that whatever implementation sort of time period comes in for overall sort of implementation, there will be a separate timeline which will be provided for any sort of localization related requirements. So if there is a sort of a hard localization requirement which is there in terms of critical personal data which is classified, then there will be a separate sort of notification in terms of what the timelines would be. And that's sort of my general point. To add to what Manish is saying, I absolutely agree with what he's saying, that there is no need for you or anybody to wait around for the privacy law to come into the picture. As somebody who has seen it, as somebody who's seen it closely, I can be optimistically say that at least those considerations which are there in terms of accountability and transparency measures, nobody is going to remove privacy by design from this. You will have to implement privacy by design. There will be data protection impact assessment. There will be a DPO which would have to be there. Those things are not going to change. The questions that will change would be about the scope of application of the law, and possibly the penalty structures might see some variations and certain considerations around data transfers and localization. But those core things that you need to do will not change. And if you're waiting around, I think you're already a bit late, because there are several organizations that have already created privacy policies, have been working tireless to create a professional workforce, even how to go about implementing. I mean, you should see the kind of privacy certification sales and trainings that are happening. That if you are delayed, then please, I would say, start immediately. Uh, this is the second question around data transfers. Yes, the data adequacy decision does take some time, but it's about a 2 to 3 year exercise. If both parties are so inclined, and India is so inclined, has been inclined for several years now. In the absence of the adequacy decision, at the moment, transfer generally happens through the standard contractual clauses, which have been revised in the post sort of shrimps to judgment fallout that we've seen, where the question of these government access to data has started propping up. It has not really reached fever pitch really in India, but it has become a quiet consideration, or polite inquiries are coming in from client organizations asking Indian organization to essentially give guarantees that the government doesn't have access to their data, which it's a sticky situation. But to answer just for completion's sake, there are also something known as intra-group transfer schemes and binding corporate rules, which can be utilized for data transfers. But that is an even sort of longer bureaucratic process of getting a group-wide BCR approved. Small distinction, standard contractual clauses are between two different entities, BCRs between the same group of companies. Yeah, that's it.
Thank you, Anand. Parminder, there is a question specifically to you. I mean, the person asking the question actually just wants you to answer this. Why similar approach has not been pursued in other countries when it comes to non-personal data and protection of such data? Question mark. Is it anything to do with the database directive in the EU and other similar activities around the world?
See, the database directive is own largely failed instrument. Even EU's own assessments have talked about it. So, but I think I see the connection here. The database directive was also trying to deal with the economic resource aspect of data. And that connection is here, that India is the first one which has tried to deal through the NPD committee, the economic resource aspect of data, which is very different from the human rights aspect of data, which is the privacy things. Now, is data an economic resource of me and people in my locality who may be taking some services from the local grocer or somebody? Is it a collective economic resource or not? And nobody has touched the economic resource dimension. That's your question. Yes, it's largely due to the global political economy. You go to the WTO, they are trying to negotiate an e-commerce chapter there, and how India is very much against that. All this is about trying to create a certain dominant digital economy model across the world, which is resisted by others. And the data flow versus data ownership, economic resource. Now, there's a very funny thing, and the last thing I want to say, that everybody agrees that data is the most valuable resource worldwide or in this era. Land was once the most important, then there were machines, and now it's data. But if data is the most valuable resource, I have never been able to understand why should it flow freely. Why wouldn't there be certain forms of collective and individual claims to that resource? Okay, use my resource, but give me 30% back whenever you produce a valuable product and all. And all this is not just wishful thinking. That's what is being talked about now. And why the West doesn't do it, I talk with a lot of people in Europe. Europe wants to do it because Europe is getting relegated in the bipolar AI race, which is led by China and US. So the middle level people in EU want to do it, still don't have a political will. The issue is the political economy of the world has not allowed West to touch that question. And India is touching that question. And South Africa has started to touch that question because they are on the wrong side of those neo-colonial world structure.
Avirup, just to humor the situation, we don't need to always be the followers, right? We can create our own and let the world follow and set the right example. So I think I totally agree with what Parminder is saying, that let us, we need not wait for world to decide if they really want to have a non-personal data equivalent, law or not. And probably if it works well with the likes of Parminder and the other technocrats and and policymakers, I think nothing like India can be the front runner and let the world follow.
Absolutely, Manish. And hopefully we'll have a couple of more conferences to contribute to that messaging to the government and other public policy bodies. Puneet, there is I mean, again, I'm asking this question, but of course it is open for anybody to answer. Maybe this is a little premature, but what do you think would be the role? I'm trying to paraphrase. It's a very long question, but let me paraphrase it. What do you think is the emerging role of data fiduciaries and data controllers? Do you think that the precise question is whether data fiduciaries must do more than data controllers? the implementation issues for data controllers and data fiduciaries. I'm kind of merging two questions together. What do you think we are looking at?
So as I said earlier, when you look at things like consent and stuff, the extent to which a user controls or has control of the data is quite limited. But to the extent to what a data fiduciary does, to me, it's always going to be dictated by the law. So I gave you examples, for instance, when it comes to things like AI and emerging tech, a lot of the conversations are in fact led by the tech companies that hold these data. They're trying to act responsibly. But there is a limit to which they can do it themselves, because at the end of the day, they act with a profit motive. Like, very few people are going to give up the motive, are going to act purely out of public interest, because that is simply not their role in society. So I would think that we need clearer legislation, clearer. I think I caught a little bit of what was said in the earlier session about articulating data in the public interest as a corporate social responsibility. Again, there India has a very unique model of corporate social responsibility. Maybe there can be ways in which that sort of a model can be worked out. Parmandar's committee has said a lot of interesting things about how NPD needs to be shared and things like that. I don't, as a commercial lawyer, I don't know how workable those solutions can be, but there's definitely conversations to be had there on what more can be done. But I'm sorry for beating a dead horse. You can't really have those conversations until you have the framework of a data protection legislation to base that off of, because we're looking at a paradigm shift from what we have and what is to come.
Sure, Puneet. Anand, do you want to add a little bit to that? Because I know you have had experiences of making being involved with the government on this matter. What do you perceive the role of data fiduciaries and controllers be in this country?
I think the position and the whole point of this whole re-christening the data controller as a data fiduciary is to have a greater sort of trust between the individual and have a fiduciary responsibility. I think this was one of the points of discussion in the last conversation we were having as well. So it sort of ties up really well with Parminder's point earlier on in terms of understanding the policy objectives, etc. And in that sort of context, the regulator and the courts, if they would get involved, there will be a higher scrutiny on these data controllers now, because they have been elevated from just a controller to having a fiduciary relationship with the individual. So you can expect higher scrutiny. So that would be my answer with respect to that question. I was also a bit confused. Was this question about data controllers and data processors, or was it?
I mean, the question was about data controllers and data fiduciaries, but please do add about data processors also.
Okay, so in that sense, I think the question, if that was the intent of the question, then the responsibilities are pretty much very much in the sort of the side of the fiduciary. Most of the responsibility of compliance rests with the fiduciary, and other things flow contractually to the data processors, except for 3-4 things such as you're not required. It's kind of similar to GDPR. There cannot be any subcontracting without the further sort of permission of the data controller, which is an issue, which will become an issue, I see, in this Indian ecosystem as it emerges. And the other thing are security safeguards. I think nobody is exempt from having appropriate security safeguards. So we call it security for privacy. So something like encryption controls and other anonymization techniques, etc., even organizational things. So those responsibilities are there on the data processors. So data processors virtually have 3 direct applicability provisions, while the controllers have a whole host of requirements that they need to comply with.
Sure. We are almost run out of time. I just have 1 minute for so any last minute additions, Manish or Parvinder, before I kind of formally close the session?
I just to agree that Anand's point of this data fiduciary matches very much, as he also said, with what I was saying. I think though there is no difference, I mean, GDPR may be stronger, but use the word controller, and here we use the word fiduciary, because we are at the thin side of the wedge of a digital society. And these policy objectives and the larger framings are going to define the thing. And I think that example which Anand gave of this word connecting to the political principles is a very good example of what I've been trying to say.
Thank you everyone for a wonderful session and round of discussions. Extremely important issues emerged which should need time and reflection, and hopefully we'll be able to organize more meetings and conferences under the leadership of the Jean Monnet Chair at JGU. Thank you, Professor Indranath Gupta, for sort of organizing the conference and the leadership of the Jean Monnet Chair. Thank you, Isha, for providing us such valuable assistance. We could not have done this program without your help. I think we are the next segment. I think Professor Srijit is speaking. Indranath?
Avirup, Srijit is having some internet issues, so I'll be stepping in. Yeah.
Okay, thank you.
Thank you, Avirup and OP Jindal. Wishing you the best for the rest of the seminar. Thanks for having me. Bye for now.
Thank you, Manish. Thank you, Manish.
Thank you.
Thank you, Arjun.
Thanks, Avirup.
Thank you, Avirup, for this wonderful session. I think, we had a brilliant day, and we looked at data privacy and data protection measures at different levels. We looked at it at the conceptual level. We also had a very strong session where we looked at the lessons that we can learn from the European Union, as well as what all are happening in that part of the world. And of course, this session talked a lot about the challenges that we must overcome in implementing data privacy. I must say that at the end of the day, it all boils down to, if I may borrow some of the words from some of the panelists, it all boils down to how well we can implement. I believe what we have seen, at least in GDPR, and if we go back to the old directive of 1995, it was a lot to do with the implementation and how well things have sort of shaped up in the future. In India as well, I believe, and this is something that was raised by one of the panelists, I can't remember who raised this, but it's very important the kind of role that the DPA would play. It's very important, the time that one would need to spend before we see, PDP acting in full throttle. So the time that one must have as a data controller or a data fiduciary, it's so very important. We see often that even in the European Union, that there are a number of establishments who are liable under GDPR. They're struggling even now to understand that what kind of compliance mechanisms that they would have. A final thought, before I deliver formally the vote of thanks. I think DPA also has another crucial role, which of course didn't come up, but we can always discuss this point later on. The crucial point would be to share to guidelines, as we have seen number of data protection authorities sharing with data controllers. And these guidelines are extremely crucial for data fiduciaries to be compliant of the expectations that we have or would have under PDP. At the end of the day, it will take a lot of time for us to understand as data controllers and as individuals and as other stakeholders to ascertain the whole structure of what the law is all about. But of course, this is just the starting point, and let me also, deliver the vote of thanks. I can't thank so many people, but let me, and always I believe that it's always important to thank as much as you can. But let me first start with the participants and the speakers. Of course, starting with our ambassador of the European Union, His Excellency Mr. Yves Astuto, who he delivered the inaugural address. our Vice Chancellor, Professor C. Raj Kumar, Professor Dr. Mohan Kumar, who is a former ambassador to France and Bahrain. And then, of course, my colleagues, moderators, Professor Krishna, Professor Chitresh, and yourself for sort of moderating all three sessions. Then our friends from Australia, from Melbourne Law School, Mark and Ginny, a friend from Nanyang Business School, Altaf, friend from Shulini, Nandan, and then Professor Paulo from Maastricht University, Professor Romeo Kader from Utrecht, then Fabrizi from UNY Global Data Protection, Professor Lucille from University of Naples, and then Parminder, then Puneet, Anand, and Manish, and in the final session. And of course, none of this could have possibly, could have possibly happened without the able help of Isha and Shweta and all the research fellows, Parth, Anuja, Satish, and all my other colleagues in JGU, the IT team for their wonderful support throughout the day, the AV team, the media team, and all others, the Vice Chancellor's office, the Registrar's office. And I hope I have not missed anyone. And if I have, I apologize for that as well. But thank you again for this wonderful day, that we have achieved, and thank you again for all the speakers and participants for spending time with us, and we hopefully will connect in some other event as well. Thank you again. Have a great evening. Thank you.
Thank you.
Thank you, sir.
Sir, can I end the session?
Yes, thank you.
Thank you, sir.